Okay, good morning. We are on the record on case CR 22-21-1624, State of Idaho versus Lori Noreen Vallow. The matter is continuing through trial. State continues with its case in chief. The court would note the prosecutions here present, as well as the defendant and the defense. The court had a conference with counsel this morning in regards to a legal issue that's arisen in the case with the current witness that's being questioned, and that's Mr. Pawlowski. On cross-examination, the defense has indicated it wishes to have admitted and published certain recordings that were made by the witness, and the court is considering whether or not those should be admitted in the case or be allowed to be published to the jurors. The court's determined that it's a legal issue that would be best determined outside of the presence of the jury, since there needs to be a proffer to the court about what the contents of the exhibit may demonstrate, and it would be improper for the jurors to hear that in the event that the court determines the evidence is not admissible. So at this point, I'd like to hear argument on the record as to what is intended to be introduced here in these recordings. If the defense could lay a record of that, including any proffer of what you would say the recordings would show and how those would be relevant and admissible. And then if there's any objection, I'll hear that from the state. So, Mr. Archibald.
Your Honor, first of all, I'll point out to the court that I did ask for Ian Pawlowski to be dismissed yesterday, that he not be allowed to testify at all. But since he was allowed to testify, Mr. Pawlowski has now testified that he is what a defense lawyer would call a snitch. A secret recording at the direction of law enforcement. So Mr. Pawlowski, he's testified so far that he dated Melanie Bedreau for, I can't remember, a couple of weeks. They got married in Vegas, and then he contacted law enforcement a week later, and at the direction of law enforcement, he became a snitch with some secret recordings. So the state has asked Mr. Pawlowski some of the content of these secret recordings, and the witness has identified a couple of issues. That the cops are possessed, that neither Chad nor Lori make any confessions of a crime. So in preparing our cross-examination, we have gone through these recordings. They were provided in discovery. I will note that we reviewed them last night. I sent an email to the prosecutors pointing out that these recordings are in the state's discovery disclosure dated August 9th of 2021, Addendum A. They're listed on the state's witness and exhibit list dated March 20th of 2023 on page 15 of 18. They're listed on our witness and exhibit list dated March 20th, 2023, page 6, item 1, where we just say anything that the state has is ours as well for witnesses and exhibits. So this recording that we would like to play this morning is from Ian Pawlowski, recording number 9. It's on December 12th or December 13th. It's a conversation secretly recorded by Ian Pawlowski. His new wife, Melanie, is talking on the phone with Chad Daybell and Lori Daybell, and they are discussing several issues: the death of Alex, the religious issues, a blessing from Chad, and I'll remind the court that these religious issues are charged by the state as an overt act, that this conspiracy that my client is being accused of is due in part to religious issues, religious beliefs, that the religious beliefs are in and of themselves an overt act, a part of a crime. So that's why we would like to play recording number 9. The witness has identified it. He's admitted that he recorded it, that he has made several recordings, and we believe this tape is not burdensome in nature. There are several hours worth of tapes. This one is less than an hour. I think it's about 50 minutes, roughly, give or take. And so that is why we would like permission from the court to play this recording.
Let me just ask, Mr. Archibald, in lieu of publishing or playing the recording, why would you prefer that versus just being allowed to cross-examine on the contents of that recording and then perhaps have an option if you were to impeach the witness with inconsistent statements versus what he says on the stand in relation to what's in the recording?
The recording is the best evidence. It contains the statements of the religious issues as alleged by the state. It contains the actual statements. The state has tried to get Mr. Pawlowski to summarize. We don't believe his couple of statements that he's made about the summary are a fair and accurate summary of what happened here. So we would prefer the best evidence, which is the recording itself.
All right. Thank you, Mr. Archibald. Who's going to argue any objection by the state?
I will, Your Honor. All
right, Ms. Blake, what's the state's response to the proposed admission of these recordings?
Thank you, Your Honor. First, I would indicate, I think it is objectionable to refer to the witness in this case as a snitch. In this case, what Mr. Pawlowski had testified to is he had concerns for his own safety and the safety for those around him and was trying to assist police in locating missing children. So I did take objection to that. Outside of that, with regard to Mr. Pawlowski's testimony, I don't think at no point was he asked to provide a summary of any recordings. He was asked about making the recordings, but prior he was asked about some of the religious teachings that Lori purported to have and that she either taught or told to him. With regard to the recordings themselves, there's several issues with them. The first one being hearsay. We have different individuals on there, Melanie, Lori, Chad, and Alex as who's purported to be on there is my understanding. With regard to that, I recognize some of those individuals are not Lori, but specifically with regard to the defendant, statements are allowed for use against a party by the party opponent. They're not generally allowed to be introduced by the party themselves into a case. So I think there's a problem with that. I do believe that these would be contain potentially self-serving statements, and not in the sense that she knew she was being recorded, but in the sense that the defense is going to try to use them for the truth of the matter. If they're not going to be used for the truth of the matter, then we get into the fact that they simply aren't relevant. With regard to any statements made by the others, statements made by a co-conspirator, there's case law saying those are not necessarily allowable by another co-conspirator. Again, they're allowed to be used by the party opponent, but not another party in the case. And maybe this is the one that Alex was not present for, but that would apply to Chad as a co-conspirator. So given the concerns with that, because I think it does become a circular argument that either it is hearsay and it is being admitted to prove the truth of the matter, and or it is a self-serving statement, if it's not being used for any of those things, then it wouldn't be relevant. Further, the defense has continued to say that religious beliefs have been made a part of this case and that it's an overt act. I want to be very clear. Religious beliefs are not an overt act as charged by the state. What the state has charged is as an overt act or included as an overt act is that the defendants espoused religious beliefs or purported religious beliefs, and the theory being that they use those to try to manipulate and control others. There's been no overt act that they actually held or believed these things. So if that's what's going to be demonstrated as well, I do not think that's contained within the charging document of the state, and that was not the intention of that overt act. So for all those reasons, we would object to the playing of the tape of the recording at this time. And we believe the defense could cross on what has been asked. They have access to the tapes, they've listened to them, and they can cross Mr. Pawlowski regarding those.
All right. Thank you, Ms. Blake.
May I respond, Your Honor?
Yes.
To something she brought up. In a conspiracy case, what Chad says is not hearsay. We've allowed a lot of Chad's statements in during this trial, weeks and weeks worth of Chad's statements. And the reason is because co-conspirator statements are not hearsay. Same is true with Alex. Alex is charged as a co-conspirator. His statements are not hearsay. The state has also alleged unknown conspirators. This could include Melanie Bedreau, Melanie Pawlowski. So her statements as a co-conspirator would also not be hearsay under the conspiracy rules. So this is not a self-serving statement. Lori didn't know she was being recorded. No one knew except Ian and law enforcement. And so that's why this is admissible.
All right. Thank you, Mr. Archibald. If you give me a moment here, please. All right, I'm going to take a brief recess to chambers to discuss this legal issue with my staff attorney and develop a decision on that. It shouldn't take long at all, and we'll advise the jury that they're being held while this decision's made. So just as soon as we can sort this out, I'll come back on the record, make a ruling on the matter, and then we'll have the jurors brought in to start with additional testimony.
All right.
Thank you. Please be seated. All right, thanks for your patience. The court is back on the record on case CR 22-21-1624, considered a request by the defense to play a recording that was made by the witness who's currently on the stand, Mr. Pawlowski. There's been an objection made by the state citing concerns that it would violate the rules of evidence as it relates to hearsay. Some other arguments made by the state is that there would not be adequate foundation or it may not be relevant. On those points, the court does find that there may be relevancy because at least some of the content could have been raised in direct examination where it was under direct of the state that the witness indicated the recordings existed and made some reference to those recordings. In addition, court believes a foundation could be established by the witness since the witness is the party that did create the recordings and would likely be able to identify those as the recordings that he made at the request of law enforcement. The issue that comes up then is whether or not this would constitute hearsay and be excluded by the rules of evidence as it relates to hearsay. And hearsay rules have a lot of exceptions. One of the exceptions that's been argued by the defense is under the Rule 801 D2E that talks about statements of a co-conspirator, and in looking at the rule there on 801 D2E, it's not hearsay if it's made by a co-conspirator during and in furtherance of the conspiracy, and that would be offered by an opposing party. So here the court finds that would not apply because it's not, first of all, the opposing party that's offering these statements, it's the party themselves, and second, there's no indication that there are indications within the recordings that the statements made were in furtherance of the conspiracy. So the court's also done some research in case law. There's a case, State versus Rolon, R-O-L-O-N, 146 Idaho 684, that talks about whether or not all conversations between co-conspirators are admissible as not being hearsay if looking at that rule, and talks also that it's a limited exception, that it's limited to statements that are made in furtherance of a conspiracy. Having considered that, the court has also considered the argument on the completeness doctrine and whether or not any of the statements made on direct were subject to the completeness doctrine, but they were basically generalized statements, and haven't heard any testimony at this point that would satisfy the need to correct what the witness said or impeach him through the means of the completeness doctrine. So with those findings, then, the court does find that the recordings would constitute hearsay and are not admissible under the hearsay rules. I would, however, indicate that on cross-examination, if the witness were to contradict the contents of those recordings, I think that may open another opportunity for them to be played as a means to impeach the witness, which would likely be permissible at that point. But with the state of the record where it is, the court finds that the hearsay objection made by the state will be sustained and will not allow the playing of the recordings at this time. So that's the court's ruling on that issue. Do you have any questions on my ruling, Mr. Archibald? All right, thank you. Any questions from the state?
No, Your Honor.
Okay, thank you. With that, then, we'll have the jurors brought in, and Mr. Pawlowski can resume testifying from the stand. They're bringing the jurors. Thank you.
Accounted for, Your Honor.
All right, thank you, Mr. Bailiff. Please be seated. All right, ladies and gentlemen of the jury, welcome back this morning. I understand they've all submitted their juror affirmations today. Is that correct, Mr. Bailiff?
Yes, Your Honor.
All right, thank you again for your continued service. Apologies for the delay in bringing you in this morning. The court was conducting a matter outside of your presence as it relates to some evidence that was in dispute in the case. We've got that resolved at this time. I'll note that Mr. Pawlowski was previously sworn in this case, and I believe where we ended yesterday, the state had completed direct examination, so at this point it would be time for defense to conduct cross-examination. So, Mr. Thomas, all right, Mr. Thomas, if you'd like to conduct your cross-examination of this witness, you can do that. And before you start with your testimony, let me just confirm again with the witness, did you, between the time we ended court yesterday and this morning, did you read any of the trial testimony, look at anything about the case, or do any investigation of the case since yesterday? Okay, thank you, Mr. Pawlowski. So, Mr. Thomas, then if you'd like to commence with direct, you can do that.
Is your microphone on?
I think it is now.
Okay.
Can you hear me?
Mr. Pawlowski, how are you this morning?
Doing all right?
Good.
As can be, I guess.
Right? Okay. So, yesterday, we went through the direct examination of you, fairly brief. Let's get a little bit more background on what we were talking about yesterday, if that's okay. It looks like you met Melanie sometime in November of 2019, is that correct?
Yes.
And Melanie is your wife?
Yes.
Her name then was what?
Her last name was Boudreaux.
Okay. And she was going through, or she had just recently been divorced, is that right?
I'm not positive, but yeah, it was a few months prior that the divorce had finalized.
Okay. And do you know who her ex-husband is?
Yes.
Okay. And you've had some dealings with him?
Not personally.
Well, through court and those kinds of things.
Melanie has.
Melanie has. Okay. You don't go to court with her?
I haven't, because of COVID, I was not allowed in the courtroom.
Oh, I see. Okay. All right. And so you met her, and then you got married to her shortly after you met her. Is that correct?
Yes.
And how long had you guys dated before you got married?
It was 10 days.
10 days?
Yes.
Okay. And you got married in Las Vegas, Nevada. Is that correct?
Yes.
Okay. You indicated on direct examination that you had talked to Lori Vallow, and that you actually, I believe you said you had to ask, or not had to ask, but you asked Chad Daybell and Lori Vallow for Melanie's hand in marriage. Is that right?
Yes.
Okay. Very chivalrous. And you did that because Melanie, she doesn't have parents, or what's the deal with that?
At that time, Chad and Lori were the closest relatives that she had. She trusted them more than anybody else in her family at the time. Okay.
And do you know that whether or not her mother is still alive?
No, her mother passed away when she was young.
Right. Okay. You talked about hearing the term casting or casting out. Is that right?
Yes.
Okay. Tell me a little bit about that. What did you hear about, and who did you hear it from?
So there were references to it during phone calls that I heard. Basically, my understanding is that with casting, you're trying to expel a possession, demonic, disembodied spirit, or they were getting into this bug kind of possession that they were talking about, where something would crawl into your ear or your brain that would take you over. And so there were references to that during the phone call. Casting, you would pray to force that possession, the possessor, out of the body.
Okay, and some of those phone calls that you're referencing, some of those phone calls were recorded, is that right?
Correct.
And you recorded those phone calls?
Yes.
And that was at the request of law enforcement?
Yes.
Specifically the FBI?
Yes.
Okay. Okay. Are you currently working with the FBI in any capacity?
No,
Not in any capacity in another case or anything else?
not at all.
Okay. When did you stop working for the FBI?
It was approximately 2 weeks after I started.
So you only did this for 2 weeks? All right. Who knew that you were recording these conversations?
It's myself and the FBI.
Okay. And this was after you were married?
Yes,
And your wife didn't know you were recording?
she did not.
Does she know now?
Yes.
I want to take you to December 12th, 2019. Do you recall that specific day?
No, you'll have to refresh me.
If I were to tell you that that's the day that Alex Cox died, would that refresh your recollection?
Absolutely, yes.
Okay. That was a pretty significant date for Melanie, right?
Yes,
And you were part of Melanie's life, and you were trying to be there for Melanie.
yes.
Okay. Do you recall talking to Lori and Chad on a phone call on that day?
I know we had a phone call with them. I don't remember the specifics of it.
Okay.
It's been a few years.
And it may not have been that particular day that he died. It may have been the day after. Is that right?
It may have been, yeah.
Okay. And in that conversation, do you recall whether or not Melanie was, what was going on that particular day when you found out that Alex had passed away?
From what I recall, Melanie had been told by Chad and Lori to go to a place of safety.
Mm-hmm.
So she went to my apartment. Melanie was at my apartment. She went up to the temple in Rexburg. And that's about as much as I can remember.
So you were in Rexburg, and she was in Rexburg.
Yeah.
And is this a time when you secretly recorded her?
Yes.
Okay. And she didn't know she was being recorded?
No.
And they had put it on speakerphone, do you recall that, or no?
The recording on speakerphone?
Yeah. The phone call that she was on?
Yeah. Sometimes when they would talk, yes, it would be on speakerphone.
Okay. And do you recall whether or not Chad and Lori gave Melanie a comforting blessing that day?
I don't remember if they did or not.
Okay. You were making these recordings and then turning them over to law enforcement, is that right?
Yes.
Okay. And what was the purpose of making these recordings?
We were trying to find out if there was, we were trying to either obtain some kind of evidence. I didn't know what the FBI knew, and I was hoping, we were both, I guess the mutual hope was that we would get anything that we could use to help find Tylee and JJ.
Okay. So you went to the police or to the FBI?
I went into the Rexburg Police Department initially.
And they contacted the FBI?
The FBI was present when I arrived.
When you arrived. Okay. And how many recordings do you think you did?
I believe there were 9.
9 recordings? Mm-hmm. And did you listen to these recordings with the FBI after they've been recorded?
I've heard bits and pieces of them. I haven't ever listened to them all the way through.
Okay, when you say you've heard bits and pieces, how does that come about? They just call you in and ask you to listen to this and see if you can interpret?
No. So I've actually never listened to them with law enforcement. It's always been in the context of leading up to this trial. So it's the last time I listened to recordings was when we were summoned to the grand jury to indict Lori. Mm-hmm. And we had some brief snippets that we listened to. There was probably a grand total of maybe 10 minutes total that I heard.
Okay. And what kinds of things were in those snippets?
There were snippets with discussions between Melanie and I, and there was a phone call with Chad, Lori, Zulema, Al, and Melanie present.
And what were those recordings about?
I was questioning, I was asking questions to Melanie. There were I was trying to figure out what she was hearing, what she was understanding. I was also trying to, another recording was the one with everyone present was, at that time Melanie was sick, and so she was just calling to talk to her aunt, and everybody just happened to be on the phone call, and so they started, the one thing that stands out was Lori said she folded Satan up like a taco and sent him to Antarctica. Lori said that she was able to cast Satan out by folding him up into the shape of a taco and locking him in a box in Antarctica.
Okay. And did that make any sense to you at the time?
Nope. They were talking about spiritual attacks coming soon, that things were going to get difficult for about 2 weeks, and then everything would settle and be okay. Mm-hmm. And this was, I think that was a recording I made on December 6th.
Okay. And so you don't have any specific, you have specific recollection of the December 6th recording about something that Lori said, but you don't have any specific recollection of a blessing that was given to Melanie?
No, I gave Melanie a blessing.
You gave Melanie a blessing?
When Al died, yeah.
On the 13th?
I don't know.
12th or 13th?
It was 12th or 13th, yeah. I just gave her a blessing of comfort.
Okay. And was that when Lori and Chad also were on the phone?
No, they weren't on the phone at that point.
They weren't on the phone. But you don't recall ever being involved in a blessing with Chad and Lori?
No, I don't recall.
Do you think that there was no blessing with Chad and Lori?
No, it's very possible. I mean, blessings were flying around like flies.
What kind of blessings?
Blessings of guidance, comfort, to remove dark weapons. I mean, when I called and talked to Chad and Lori to ask their hand in marriage, Chad gave me a blessing, and he removed all dark ties from me, and he removed dark weapons from me, and he shielded me with light, and there were just, lots of different things that he was saying. So at any time there was any kind of negativity or difficulty, there was almost surely a blessing that would come at some point.
So Chad and Lori weren't giving these blessings in like a dark way. They were trying to raise you up to a higher level. Is that right?
Yeah, that's how it came across at the time. Yeah.
At the time, did it come across differently now?
I mean, given the context of it, I mean, given everything that's happened since, it feels a lot more like manipulation than it does, true intent to help.
You feel like you were manipulated?
Absolutely. More than anything, I feel like Melanie was manipulated and taken advantage of in one of the most difficult and dark times in her life.
And difficult and dark times, what are you talking about?
She was going through a rough divorce. Her children had been taken from her. This case was there's no shortage of people in Melanie's life that will abuse her and her circumstances to get what they want out of her. And Lori was one of them.
And it's your understanding that Lori was trying to get something out of Melanie?
That's what it looks like. I haven't ever seen any hard evidence of that, but in the investigations and discussions I've had with law enforcement, with attorneys, everything that's come since, it really looks like there was something to be taken from Melanie.
Let's talk about that. What kind of manipulations, what kind of interactions have you had? You seem to not really have a lot of interactions with law enforcement and not have a lot of recollection about those interactions with law enforcement. So let's talk a little bit about that. What are you talking about?
Objection, that's argumentative.
Well, that was an argumentative comment, Mr. Thomas.
All right. What kind of interactions have you had with law enforcement that you've gained where you believe that Lori has been manipulating Melanie specifically?
So there's been, in the 2 weeks that I was meeting with them, there were a lot of things that came about that didn't look like Lori was exactly being truthful with Melanie.
What was she manipulating Melanie about in those 2 weeks?
She was telling her, that Brandon's dark, that law enforcement officers that Melanie should have been cooperating with were dark, translated beings, that they were out to get them, that they were impeding their holy mission. When in reality, these officers were trying to find 2 missing children, find out what had happened with the shooting of Brandon Boudreaux.
So Lori said that you were dark.
Lori never said I was dark, no.
You said Brandon was dark. Oh, Brandon, her husband, Brandon Boudreaux.
Correct.
Okay. All right. And, okay. All right. But they never said anything poor or bad about you?
No, they did not.
And you recorded all those conversations so you would know, right?
Right.
Right. If I could have just a second, Judge.
Yes.
Your Honor, based on his purported lack of knowledge of what is recorded on December the 12th or December the 13th, we'd ask that he listen to what has been marked as Defendant's Exhibit F to refresh his recollection of that recording that he purportedly made on that date.
Your Honor, we would request a sidebar.
Very well. All right, counsel, we had a sidebar discussing the request that the witness be allowed to refresh their recollection with a recording. Based on the sidebar, the court is denying that request at this time, and you can continue with your examination, Mr. Thomas.
Thank you, Your Honor. So specifically with this Alex Cox passing, this was a big deal for Melanie, correct?
Yeah, absolutely.
She was very close with Alex?
Yeah.
Okay. Alex was her uncle?
Yes.
And when this happened, were you there when she got the news?
Yes.
How did you hear about that?
Zulema called and told Melanie.
Zulema called and told Melanie?
Mm-hmm.
And you were there for that phone call?
Yes.
Okay. And then at some point, Melanie called Lori and Chad, is that right?
Yes.
And that particular phone call was recorded by you?
Yes.
Okay. And were you trying to record all the phone calls that that Melanie had with Chad and Lori?
As many as I could without, being too obvious. I mean, there were some conversations where, for me to just walk into the room and stand around, it would have been really awkward and, just unnerving to her. Not unnerving, but just it wouldn't have felt appropriate for me just to show up and stand around and just hang out until she's off the phone. So I got as many as I could where it felt appropriate.
Well, on this particular occasion when Alex had died, Melanie was quite distraught, right?
Correct.
And she was crying,
Yes.
and she felt like she had been attacked by spiritual demons or whatever?
Yeah, I mean, so that's how she had been told by Chad and Lori that there was going to be a spiritual attack that day to get to a place of safety, and with Alex dying, that confirmed that.
And on that particular day, did you feel like that was something that she was actually being led to, or is this something that she was being manipulated?
I have no clue how Chad and Lori could have called that Alex was going, or not that Alex was going to die, because they never said that specifically, but that there was going to be something bad happening, that there was going to be a heavy spiritual attack. yeah, when Alex died, it felt very strange to me that they'd called that out right before it happened. And, you know, I think everybody at that point was grieving it. You know, that's Lori's brother.
So-
Somebody that she loved and cared about. So I think everybody was hurting. It's Zulem's husband, Melanie's uncle. I think everybody's genuinely hurting. You know, so if, you know, at that point, if there is any manipulation, it's, you know, it's kind of already been, the groundwork's already been laid for it. I don't think there was any active attempts at manipulation at that point.
So there was no manipulation on that particular aspect?
I mean, like I said, there was groundwork laid for it, you know, with all of the spiritual, I guess the best way I can explain it is, you know, there's reality, and then there's the layers of spiritual explanations that were laid over reality. And that's, you know, at that point, I don't think Lori was pushing to manipulate that particular event to hurt Melanie.
So she wasn't manipulating, you thought that was a spiritual event?
I didn't believe that was a spiritual event, but I don't think Lori was trying to manipulate Melanie.
You don't believe that Chad and Lori giving Melanie a blessing over the phone was a spiritual event?
Well, no, I mean, I guess in that context, yes, it was a spiritual event, yes. But I don't believe there was a spiritual attack that killed Alex.
No, right. But Melanie said she was. Did Melanie say anything about her being feeling spiritually attacked or feeling?
I don't specifically recall her saying that. I'm sure she. I mean, yeah, I could imagine at that point, yeah, she did. But I don't specifically recall anything that she said.
Okay. Do you recall Chad and Lori putting shields of light around Melanie when they were giving her this blessing?
That sounds like something that they would do, but I don't remember it specifically.
You don't have any specific recollection?
Right.
Okay. And how many times, you indicated that you recorded these 9 recordings in about 2 weeks, right? Mm-hmm. Okay.
Yeah.
And how many times were there spiritual blessings in those recordings?
There were just a handful that if I remember correctly, there weren't very many.
Mm-hmm.
I mean, well, yeah, I think there were a handful of them that were done over the phone.
And were you ever brought into those blessings?
Yeah.
So you also were blessing Melanie at the same time?
If I remember correctly, there may have been, yeah, I may have done that at some point. I know I gave her a blessing the day that Al died.
Okay, but specifically when Chad and Lori were giving her blessings, were you ever called in, and did you ever lay hands on Melanie's head when they were giving a blessing?
I don't remember specifically if I did, but based on how blessings were given, you know, the way they organized the blessings, that's absolutely something I could have done.
So you're saying you don't ever remember putting hands on Melanie's head while Chad and Lori talked over the phone and the three of you gave her a blessing?
I don't specifically remember it, but if you told me I did it, I'd believe it.
You don't specifically ever remember doing that?
No.
Objection, Your Honor. This has been asked and answered multiple times now.
Sustained.
All right, Judge, we have no further questions.
All right, thank you, Mr. Thomas. Redirect from the state.
No redirect, Your Honor.
All right, any objection to the witness being excused?
No, Your Honor. We would ask that he be released.
Any objection from the defense?
Your Honor, we may call him in our case in chief, so yeah, we're not going to allow him to be released.
Your Honor, we would ask that he be released from the state subpoena.
And Judge, given the, I'm sorry, may I speak?
Go ahead.
Given the posture of Mr. Pawlowski, we'd ask that he is unlikely to come back should we need him to come back. So we would ask that he not be released from this subpoena.
And Your Honor, I would just indicate there doesn't appear to be any hesitation on Mr. Pawlowski's part to be here today. If the defense wants to bring him back, I think they could.
All right, well, the court's not aware in the file of who has placed Mr. Pawlowski under subpoena. Is it the state only?
We have a subpoena. I cannot speak for the defense, but the state has a subpoena, and we would release him from our subpoena.
All right, here's what I'll do. I'll allow Mr. Pawlowski to be released from the state subpoena. However, I will direct you that before you leave, that there be an opportunity, if the defense wishes to recall Mr. Pawlowski in order to ensure his attendance, that they be provided an opportunity to serve a subpoena.
Thank you, Your Honor.
And I'll authorize one on short notice if required. Perhaps during the break you can discuss that issue with Mr. Pawlowski and see if there's any assurance that he'll appear and whether or not you need to go through the step of placing him under subpoena.
Very good. Thank you.
All right. So you can go ahead and step down. That concludes your testimony at this time, Mr. Pawlowski.
Your Honor, I apologize for interrupting. Mr. Pawlowski is here with counsel out of Arizona. His counsel indicated to me that he is willing to accept service, that Mr. Pawlowski would be willing to come back under that subpoena from the defense. If that is, in fact, their intention, he will accept service.
Okay. Thanks for that information as well then, Ms. Blake.
Sounds good.
All right. Is the state ready to call its next witness?
Yes, the state will be calling Taylor Ballard.
Very well.
Solemnly swear or affirm that the testimony you're about to give will be the truth, no truth, and nothing but the truth, so help you God.
All right. Now that the witness has been placed under oath, let me just inquire briefly. Have you viewed or listened to or in any way been advised of the testimony that has taken place in this trial since it started?
No, sir.
Okay. With that in mind, then, you can go ahead and inquire on direct. Ms. Rawlings, I'll indicate to the witness, please make verbal responses to any questions asked of you and try to avoid speaking at the same time as any attorney questioning you so we keep a clear record. Ms. Rawlings, you can conduct direct.
Thank you, Your Honor. Good morning. Could you please state your name and spell it for the record?
Taylor Ballard, Taylor-Ballard.
And Ms. Ballard, how are you employed?
I'm a health insurance broker at Ballard Insurance Group in Rexburg, Idaho.
In your role at Ballard Insurance, did you have a client by the name of Chad Daybell?
Yes.
Can you tell us about any contact you had with Chad Daybell in October 2019?
I met Mr. Daybell on October 31st, 2019. He came into my office to inquire about obtaining health insurance for a November 1st effective date because the coverage that he currently had through his wife's employer was expiring that day because she had recently passed away.
So that was for individual health insurance?
Yes.
Did he seek health insurance for anyone else?
For his children, Seth, Leah, and Mark.
And did you have a conversation with him about how he was going to get the insurance on that day?
Yes.
Briefly, what was that conversation?
At the time, Idaho was looking to expand Medicaid to adults beginning January of 2020. And so he made a comment that his income for 2020 was going to look different now that he didn't have his wife's income. And so I told him he was a possible candidate for Medicaid beginning January. And so we just needed to cover him and the children for November and December of 2019.
Okay, and did you have any contact with him following up on his request for that individual health insurance?
Yes. On that same day, I had told him that we don't normally apply people for Medicaid because it's no benefit to us, but given the situation, the nature of his situation, and his wife being a previous client, I told him that I would apply him for Medicaid for January. And we got the coverage for him and the kids November and December. And so on November 5th, I went to Health and Welfare to apply him for Medicaid for January. And the Health and Welfare interface looked up previous income information and saw that the income number that I had given them from him was higher in their records, and so they said that he would not qualify for Medicaid, but rather a tax credit through the individual market, and so I would need to get him individual coverage in January instead of Medicaid. So I texted him on that same day asking him if he could bring me a copy of his... Do you know what? I have my dates wrong. I'm so sorry. On November 5th.
I'm going to object here. I think this is a narrative. I just asked that there be a question asked.
I will sustain that, so let's start over with a new
Okay.
question, if you don't mind, Ms.
So
Rawlings.
Thanks, Taylor. Let's talk about after you checked on his income with Health and Welfare, what was the next contact that you had with Mr. Daybell?
Yes, I'm so sorry. So on November 5th, when I went to Health and Welfare, the income situation, they told me, they said, we think we've got too high of income in here. And so I took...
object to hearsay, Judge.
I'll sustain that.
What ultimately did you learn and what did you do after going to Health and Welfare?
That he possibly would not qualify for Medicaid, so Health and Welfare asked me to retrieve a copy of his tax return. So I texted him on November 5th asking if he could bring me a copy of that.
Okay. So you reached out to him by text.
Yes.
Did you hear back from him?
Yes.
What communication did you have from him?
He responded and said that he was out of state all week, and so he couldn't, and so he would bring me the tax return possibly the following week.
Okay. And did you hear from him again?
Yes.
When was that?
He brought his tax return in at some point. I did not visit with him that day, but I took the tax return to Health and Welfare, and based on that information, they found that he did not qualify for Medicaid, but rather the tax credit that I was saying before. I got mixed up. I'm sorry.
No, that's fine. Did you have a conversation with him later in November about the other forms of insurance that were available?
Yes. November 21st, I texted him and asked if he could come into the office so we could talk about those options.
Okay. And what conversation did you have with him at that time?
He did come in, and I showed him the options for 2020, and then it was just going to be for him and his son Mark at that point in January. And then he asked me that if he were to get married, how hard it was to add his wife to his policy.
Okay. So he inquired about someone else?
Yes.
What was your response to that?
I told him that it wasn't a problem to add a spouse, but we'd need to do it within 60 days of the date of marriage.
Okay. Did he indicate anyone other than this potential new wife would need coverage at that time?
Just his son, Mark.
Okay. And was there anything more about the needs of him or his wife on this November 21st date that you discussed?
No.
Anything more about the insurance coverage on the 21st that you can remember?
I just told him that I would email him the options and he could pick which and let me know which plan he wanted.
Okay. And did you hear from Chad again?
Yes.
When did you next hear from him?
I'm sorry, can I look at my notes?
Your Honor, this witness had prepared some notes in reference to her interactions with the insurance, and she has them here. I'd ask that she be able to review them to refresh her recollection on the dates.
Okay, they'll need to be reviewed by defense counsel first, please.
It's just the one in the clasp is all I want.
I'm sorry. Your Honor, may I aid in an objection to her reviewing these notes? May I volunteer an aid of an objection?
You may.
Ms. Ballard, it looks like there's about 15 pages of text writings that have some footnotes in there. Is that my understanding?
Yes.
And it looks like it's a day-by-day, play-by-play type of encounters with Mr. Daybell. Is that right?
Correct.
Okay. Is this something you do in the normal course of your business, or was this something that was asked of you by law enforcement?
I was subpoenaed to provide that information.
Okay, and you provided that information to law enforcement?
Yes.
Okay. If I could have just a second, Judge, to confer with counsel.
Yes.
Judge, can we just have a quick sidebar?
Yes. All right, there's been a request to have the records used to refresh the witness's memory. They've been reviewed by counsel. I don't know, were they supplied to the witness at this point?
Not yet, Your Honor.
Okay, they can be at this time.
Thank you.
And so, Taylor, just to refresh your memory, we were discussing, my question was when you heard from Chad again after the November 21st conversation.
Yes. He reached out to me on...
Let me stop you.
I'm sorry.
So you're going to be allowed to look at your notes to refresh your recollection, and then you'll have to close them and testify. It's just to refresh your memory.
Okay. He reached out to me on December 10th, and by phone call, and I responded to him on the 11th.
Okay. And I want to just clarify a couple things about the notes and what you provided to law enforcement, if I can. You, as an insurance agent, have a file on your clients. Is that accurate? Mm-hmm. Did you provide the insurance file or the insurance information to law enforcement?
Everything that I had on Mr. Daybell I gave to.
Okay. Did you make personal notes for your own memory and to be able to recall your interactions with him?
No.
No? Okay.
Your Honor, at this point, I'm going to make an objection that there is a discovery violation. This witness has turned things over to the state that we've not been in possession of.
Sidebar, Your Honor.
Go ahead and finish your
We
objection.
cannot adequately cross-examine her without the information that has been provided to the state. So I would object to her being called as a witness, and I would ask that she be excused.
Well, I'm not going to go that far with the objection at this point. There's been a review of the file made by defense counsel. I guess it's raised an issue which we may or may not need to take up outside of the presence of the jury. Let's have a quick sidebar on that issue, counsel. All right, thank you. At this point, there's been an issue raised as it relates to the file and whether or not it's discoverable evidence in the case. It's been argued to some extent by the defense. The court's going to make an in-camera review of the file to determine whether or not we need to proceed any further with that issue. In order to do that, we'll take the mid-morning break at this time, and we will reconvene at about 1:45 the hour and continue with the direct examination.
All right, please.
Thank you. Please be seated. Okay, we're back on the record on CR 2221-1624, State of Idaho versus Lori Noreen Vallow. We had an issue come up with an objection as it related to the file notes of this witness. There was a question, I think, of whether or not discovery had been produced, and as I understand at this point, the parties have resolved that issue. Is that correct, Ms. Rawlings?
That's correct. We were able to provide the Bates number to the defense for where this information was provided.
Okay, and so that takes care of the objection then, Mr. Thomas.
Yes, Your Honor. It looks like it may have been provided to prior attorneys prior to Jim and I coming on, but we don't remember seeing it. But we know that it was Bates stamped, and it is in our discovery.
Okay, with that in mind, then I'll just indicate, because of the nature of the objection made in the presence of the jury, I'm going to provide a curative instruction for the jurors once they come in and remind them that the evidence is to only be considered and that arguments on admissibility of exhibits are not to be considered. So we'll take care of that once the jurors are returned to the courtroom.
Thank you, Your Honor.
Thank you, Judge.
All right, so, and you have the file back, okay. Let's go ahead and have the jurors return then, please, Mr. Bailiff.
And let's wait it.
All right, please.
All right, thank you, Mr. Bailiff. Please be seated. All right, we are back on the record in this matter. Ms. Ballard is still on the stand with direct examination. Ms. Rawlings conducting that examination. Before we start again, I just want to advise the jurors there was a defense raised by, or an objection raised by the defense prior to the break. We've resolved that issue, and I wanted to just remind the jurors, you may or may not remember on the first day of trial you were given a bunch of instructions, and you'll still be getting those later. Among those instructions is an instruction that states specifically, and I'll quote, "At times during the trial, an objection may be made to a question asked a witness or to a witness's answer or to an exhibit. This simply means I'm being asked to decide a particular rule of law. Arguments on the admissibility of evidence are designed to aid the court and are not to be considered by you nor affect your deliberations." So please keep that in mind as it relates to that objection, and I would ask you to disregard it as it does not relate directly to what you will consider as evidence in your deliberations. So with that in mind then, Ms. Rawlings, if you'd like to continue with your direct, you can do that.
Thank you, Your Honor. Taylor, do you remember we were discussing, I believe, a phone call that you had with Chad in December 2019?
Yes.
And what can you tell us about that conversation?
He called me because he wanted to make sure to pay his premium for January, and I had told him that I never heard back from him from the email that I sent him with the quotes. And so we briefly went over those options, and he picked a plan and paid for his premium.
During this conversation, did you discuss coverage for anyone other than him at that December call?
Only his son, Mark.
Okay. And did you hear from Chad Daybell again later?
Yes.
When did you hear from him?
I believe it was March 11th, 2020. He came into my office.
What did he want when he came to see you on March 11th?
His original inquiry was to obtain health coverage for his new wife.
Okay. And can you tell us about that conversation?
He told me that he'd gotten married and wanted to get coverage on his new wife. And I asked him when they got married, and he told me that it was November 5th, 2019. And I told him that we were outside of the 60-day window, so that wouldn't be possible. And
Right. Did you discuss what other qualifying events there might be?
yeah, he told me that she was incarcerated and he was really worried about something happening to her, but that she was supposed to be getting out the following week. And so I said that that's a qualifying event.
Okay. Did you discuss other qualifying events?
Yeah, we talked about moving back to, moving into a state is a qualifying event, or losing coverage elsewhere.
Okay. And when you talked about moving into another state, did you discuss with him where he and his wife had been previously?
Yeah, he told me that they were living in Hawaii and that they had just come back to Idaho.
Okay. Did he ask about coverage for his wife, including dental insurance?
Yes.
And he asked about coverage for his son, Mark.
Yes.
Did he talk about anything else relating to the background of his wife, what her needs would be?
No.
Okay. So let me just break this down a little bit. He talked to you in November about possibly getting married again, right?
Yes.
At that time, he did not ask for coverage for anyone else, though.
Correct.
Okay. Did he tell you back in November anything about this potential new wife?
Yes.
What did he tell you?
He told me that she lives in Kauai, and so that they would live there half the year and in Idaho for half the year. He told me that she was a widow and she lived off her husband's Social Security death benefits.
Okay. And so fast forward to March, the March visit, when he was trying to get the insurance, did you ask him if you could double check some information?
Yes.
Okay. Did you notice anything else about Mr. Daybell between your visit with him in November and your visit with him in March?
Physically, I just thought he looked thinner and tanner, which made sense if he'd been in Hawaii.
Okay. Did he tell you who his new wife was?
Yes.
What did he say?
He wrote on a sticky note, Lori Ryan Daybell.
And did he indicate whether there was coverage needed for anyone else?
No.
Did he state whether or not she had any kids?
No.
No, he didn't state it, or?
I went through the application process like I would with anybody, just verifying, is this your phone number, is this your address, etc. And one of the questions is, are there any children? And when I asked that, he said no.
Okay. If I may have just one moment, Your Honor.
Yes.
I don't have any other questions at this time.
All right. Thank you, Ms. Rawlings. Mr. Thomas Cross?
Thank you. Yes. Morning, Ms. Ballard. You had filled out some information for Chad to present to the Department of Health and Welfare. Is that correct?
Yes.
And some of that information, I think you said, was had to do with his income because he may qualify for Medicaid.
Correct.
Okay. And what was his income?
I think, I don't remember, this was a long time ago, but I think at the time he had said that his income without his wife's would be around $20,000.
Okay. I went through your notes, and would it refresh your recollection if you went through your notes and looked at that particular?
Definitely.
Okay. Can we give that to her?
And again, I'll just advise the witness that if you're using those to refresh your recollection, don't just read from the notes, but look at them and then close the file once you've done that.
Yes, sir.
And just to kind of speed things along, there's an actual piece of paper that's from Health and Welfare that's attached to those notes or inside that packet.
So Chad told me that they wouldn't have any income, and then Health and Welfare System interfaced $30,000.
$30,000?
Yes.
That was his income for the year?
That's what he was, yeah. Mm-hmm.
Okay. Thank you. No further questions.
All right. Thank you, Mr. Thomas. We'll have well, let's see if there's any redirect. Ms. Rawlings?
No, Your Honor.
Okay. Without any redirect, then, can this witness be excused?
Yes, we would ask that she be released.
No objection.
Okay. You can be excused. Make sure to take your file with you. State can call its next witness.
State will be calling Angela Yancey.
Swear or affirm that the testimony you're about to give will be the truth, full truth, and nothing but the truth, so help you God.
Thank you.
All right, before we get started with testimony, let me just inquire of the witness, Ms. Yancey, have you reviewed or listened to or read or in any way seen any of the trial testimony in this matter since the trial started?
No.
Okay. As you testify, please talk right into that microphone so your voice is picked up clearly. Please make verbal responses to questions being asked and try to avoid speaking at the same time as anyone questioning you. With that in mind, Ms. Rawlings, you can inquire.
Thank you, Your Honor. Good morning.
Good morning.
Would you please state your name and spell it for the record?
Angela Yancey, ANGELA-YANCEY.
Angela, where were you employed in 2019?
Sugar Salem School District.
How long did you work there?
7 years.
What was your job title?
I was the payroll and benefit administrator.
And what were some of your job duties with regard to that position?
I processed payroll for all of the employees, and I assisted with all of their benefit administrations.
Was it part of your job to process employees' insurance applications?
Yes,
And this would have included life insurance.
correct.
Are you familiar with Tamara or Tammy Daybell?
I am.
Do you know if she worked for the Sugar Salem School District?
Yes, she did.
What was her job?
She was the elementary librarian.
And I think you mentioned you processed benefits for employees. As part of that, did you run benefit meetings for the school employees?
Yes, every year during open enrollment, we would go to each building and hold meetings that informed them of any changes to their benefits, and we brought forms if they were to make any changes.
So you informed them of any changes. Would you also discuss open enrollment periods, life insurance changes, that type of thing?
Yes.
And when would the open enrollment period be for the school district?
It started in August, excuse me, and they had until the middle, about the 12th to the 15th of September, to get the applications back to us to be effective as of 9/1.
And what types of forms did you provide to the employees at these meetings?
Change forms for their medical, dental, vision, life.
And do you recall if Tammy Daybell made a change to her life insurance policy in 2019?
She did.
Do you know if she submitted an application for that change?
Yes, she did.
Did you process that?
I did.
If I were to show you a document purported to be part of that, or the application or part of that, would you be able to recognize it?
Yes.
And Your Honor, I will be asking to have States Exhibits 151, 152, and 153. These have already been admitted, but I'd like to publish them for the jury so that the witness can reference them.
Okay.
And Your Honor, may I have permission to publish so the witness may reference?
You may.
Easier to read. Oh, goodness. I think it's more like, is it easiest to read that way?
Yes.
Okay. Do you recognize what's been marked as States Exhibit 151?
I do.
What is that document?
This is a change form to her voluntary life insurance.
And do you know, when you say change form, is that a different application than had been previously made?
Yes. When she was originally hired, they when I present the life insurance, voluntary life insurance to them, they can elect a minimum of $10,000. And so that would have been her original form. And then the way the benefits worked is any time after that during open enrollment, you can increase it.
Okay. So this was a request to increase. Do you remember when she was hired?
I believe in 2017.
Okay. And do you know what the amount of life insurance was on that 2017 application?
She elected the minimum of $10,000.
And in 2018, did she make any changes or request any changes?
She did not.
So then in 2019 on this document, she requested to increase the policy.
Correct.
And did you process that paperwork?
I did.
Who signed that request for the increase in benefits on her application or the change form?
Tammy did, and because she elected spouse coverage, her spouse also signed it.
Okay. And would that be on a different page than this first page?
Yes.
And when was this form signed and dated?
September 8th, 2019.
And then the form would have to be turned into your office, is that right?
Correct.
Okay. What date would the increase in the life insurance have gone into effect?
9/1.
Okay. And so what was the total amount of the life insurance policy for Tammy Daybell once this change went into effect?
So she elected the max, which was 5 times her salary at the time, so it was $80,000, and then she also had a $50,000 from the group life.
Okay. And were you involved in or did you assist in a claim being submitted with regard to collecting on her life insurance policy?
I was.
I'm going to show you what's been marked and admitted as State's Exhibit 152. If I may, Your Honor.
You may.
And do you recognize that document?
I do.
What is the title of that form?
It's a beneficiary statement.
Who submitted the beneficiary statement form?
Her husband, Chad.
And did you meet with Chad Daybell when he provided that form? Or provide him with that form, excuse me.
I did.
Do you recall when you first met with him?
He came into my office Monday morning after Tammy had died. So she passed away between Saturday and Sunday, and he was there Monday morning.
And I want to back up a little bit. You had said you worked in HR for the Sugar-Salem district since 2013, is that right?
Correct.
Where did you work before that?
Madison School District.
And were you responsible for helping employees of both school districts process life insurance claims?
I was.
How many times would you say you have assisted with processing life insurance claims?
I'd say roughly 15 or so.
And so you said that Chad came in on October 21st, which was the Monday after Tammy had passed away. Mm-hmm. And in your experience, was it unusual for a spouse to come in that soon to process a life insurance claim?
In my experience, yes.
What conversation did you have with Mr. Daybell when you provided him with the form on October 21st, 2019?
I explained to him that we could not submit a life claim until we had the original death certificate to go with it. And he said, that's okay, I've already ordered 8 of them.
And in your experience, how many death certificates do most people order?
When they share that information with me, I've heard maybe 3 at the most.
And do you know when Chad returned to submit this beneficiary statement?
He returned on October 25th. I was out of town, and so my coworker told him that he would need to come back on the 30th when I was back in town, and he was there on the 30th.
And who fills out the information that's contained on that beneficiary statement form?
Chad did.
So the information regarding attending physician and such is filled out by the spouse typically?
Correct.
And drawing your attention to the notation that she died in her sleep, would that have been filled out by Chad Daybell before bringing the form back to your office?
Yes, it was.
Now I'm going to show you what's been marked as State's Exhibit 153. And do you recognize this?
I do.
What is the title of this form?
It's the employer's and/or administrator's statement.
And who fills out that form?
I did.
And so you recognize this as the form that you filled out?
Yes.
What did you do after Chad had brought in the beneficiary statement?
I completed this statement and then attached the death certificate and submitted it to the life insurance claim or company.
And so when would you have filled out the form?
I did it that day that he brought it, the 30th.
Brought in the death certificate?
Mm-hmm.
Okay. Now, we talked about the increase in life insurance that Tammy had requested in September. What's the amount of life insurance on this form, if you can see it?
It says $50,000 for the basic, which is the group life, and it says $10,000 for the voluntary. Her change form had not been filed in her file yet, and I used the information from her file.
So you didn't have the change or the updated or the increased information?
Correct. But it had already been submitted to the insurance company, so they had the correct information.
And so what was the correct amount?
$80,000.
And so what was the total amount that would have been paid out for this life insurance claim?
$130.
And do you know if that's the maximum amount that could have been requested for an employee in Tammy's position?
Yes.
I don't have any other questions, Your Honor.
All right, thank you, Ms. Flemings. Cross-examination.
Thank you, Your Honor. So there were a few different life insurance policies on Tammy, is that right?
With our school district, there was only 2.
Okay. One of them was the group insurance, right?
Correct.
All right. And that's offered through the school district as a free bonus for every employee of the school district, correct?
Every eligible employee, yes.
Any eligible employee is somebody who works full-time.
Correct.
All right. So if you're a full-time employee, you don't really have to fill out anything. It's just part of your package, your benefits package.
Correct. There's not an enrollment form. We just require a beneficiary form.
Okay. And in this particular case, the beneficiary was Chad Daybell.
Correct.
And she indicated that Chad Daybell would be the beneficiary.
Yes.
And he didn't come in with her to fill out that beneficiary form to your knowledge?
Not to my knowledge, no.
Okay. So the $50,000 was offered to every employee. So now we're going to the $80,000. The first year when she enrolled was a $10,000 enrollment, the bare minimum you can get, right?
Correct.
And I believe, if I'm correct, and I'm probably not, it was somewhere around $1.93. Was that a paycheck or a month?
Well, the school district pays monthly, so
Okay.
it'd be the same.
So it'd be $1.93 a month
Correct.
for the $10,000 life insurance?
Correct.
All right. And then I believe the $75,000 one had something around $15 a month. Is that right?
I don't know the exact amounts. It's done by age, so whatever her age was at the time is what it is. But
On the form that, I guess we can bring up let's bring up the last 2 exhibits, State Exhibit 153 and 152. I'm sorry, I'm gonna have you look at 151. Can you read that okay?
I can, yes.
All right. So we were just talking a little bit about the $10,000 one, and it is what, $1.98 a month? Is that right?
Yeah. It's a little blurred, but that looks right.
Okay. And then the $75,000 one would be how much?
$1,470.
$1,479, or is that 70? I'm like 70. You're right. My bad. $1,470, and then $80,000 would be a little more than the 75,
Correct.
right?
Right.
Okay. And so in your work, that this is part of your work, is it often? What is your experience with how much people normally get? Do they normally get the maximum?
It all depends on the individual and what's going on in their life. We just explained that if they initially elect the $10,000, then anytime in the future they can elect up to their 5 times their salary. And so it just depends on the individual.
Okay. And that open enrollment is only one time a year?
Correct.
And it's about a 30-day period?
Correct.
And in this particular date, it was when, August to September, or when was it, do you remember?
For a school district, yes. We started in August when they come in, when the employees come back to work, and then they have until about the 15th. It's a grace period in September, but it's still effective 9/1.
Okay. So this was within the grace period?
Yes.
Okay. Thank you. No further questions.
All right, thank you, Mr. Thomas. Can you redirect?
I don't have anything, Your Honor.
All right, can the witness be excused?
Yes, we would ask that she be released.
No objection.
Okay, that'll conclude your testimony. Thank you for appearing. The bailiff will assist you leaving the courtroom. State can call its next witness.
The state will be calling Colin Nesbitt. Ms. Smith will be questioning him.
Thank you.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, thank you.
All right, before we commence with testimony, let me just inquire of the witness. Officer, have you reviewed in any way any of the trial testimony in this case, including reading it or hearing it from any source?
No, sir, I have not.
Okay. As you testify, please talk directly into that microphone, use verbal responses to any questions asked, and please avoid talking at the same time as anyone questioning you so we keep a clear record. With that in mind, Ms. Smith, you can inquire on direct.
Thank you, Judge. Good morning.
Good morning.
Can you introduce yourself to the ladies and gentlemen of the jury and spell your last name for them, please?
My name's Colin Nesbitt, and it's spelled Nesbitt.
Sir, how are you employed?
I'm employed with the County of Kauai Police Department in Hawaii.
How long have you been a police department in Kauai, Hawaii?
16 years.
What is your current position?
I'm a detective with the Major Crimes Section.
And how long have you been a detective in the Major Crime Section?
4 years.
And prior to that, what was your role?
Prior to that, I was a detective in the Property Crime Section for 2 years, and then I was in Narcotics Section for a year and a half.
Okay. And what sort of training have you had as a police officer in Kauai?
I've had the basic academy training. That's approximately 5 months long. And then I've had additional training, approximately about 400 hours. Approximately 200 of that would have been in major crimes such as sex assaults, homicides, death investigations, and robberies.
And so in your role as a major crimes detective, did you have occasion to work and have contact with Lori Vallow?
Yes, I did.
What was your contact with Lori? What was your first contact with Lori Vallow?
My first contact with Lori Vallow was January 25th, 2020.
Okay. What caused you to come in contact with Lori Vallow in January of 2020?
I was assisting members from the Rexburg Police Department to serve a legal document.
Okay. And how was it that you came to be a part of assisting Rexburg, Idaho police officers in serving legal documents on Lori Vallow?
Oh, well, they all flew over to Kauai for whatever their investigation was into the matter, and then we had an operational briefing, and they asked for assistance to help locate and serve that document.
Okay. And was Lori Vallow, and there's water there if you need it.
Yes,
okay.
Thank you.
I'm assuming, given your answer, that Lori Vallow was located?
Yes, ma'am.
Where was she located?
She was located at the address of 4141 Queen Emma Drive in Princeville, which is a condo complex, and she was in the swimming pool area.
Okay. Who was with her?
Chad Dabo.
Okay. And who went up to serve her those legal papers?
Detective Cataluna served those the papers.
Okay. Who was present from law enforcement when Detective Cataluna served those papers?
Also with Detective Cataluna was Lieutenant Christopher Collio and myself.
Okay. Were you with the detective and the lieutenant the entire time that they went in to serve the papers on Lori Vallow?
Yes, ma'am, I was.
Was that service recorded in any way?
Yes, it was.
How was the service of papers on Lori Vallow from Idaho, those papers from Idaho, how was that service completed?
She was provided a copy, and then she was asked if she had any questions.
Okay. And after that happened, was that recording captured and saved?
Yes, ma'am, it was.
And were you the person responsible for making a copy and saving the recording of the service on Lori Vallow in Hawaii?
Yes, I was.
Okay. And did you make a copy and turn it over to anyone?
Yes, I did.
Who did you turn it over to?
The Rexburg Police Department.
Okay. And prior to coming to court today, did you make another copy for use in trial of that recording of service of papers on Lori Vallow?
Yes, ma'am, I did.
Okay. And did you put it on a thumb drive and mark it with your initials?
Yes, ma'am.
Your Honor, I'd ask the court that the court hand Officer Nesbitt State's Exhibit 205.
You may be.
Thank you. And I apologize. I think I called you officer. It's detective, right?
Either one is fine.
Okay. Detective, do you recognize State's Exhibit 205?
Yes, I do.
Okay, what is it?
It's the thumb drive that I saved a copy of the recording on.
Okay. And did you prepare that thumb drive?
Yes, I did.
Is it, other than the recording of the service of paper on Lori Vallow in January of 2020, is there anything else on that thumb drive?
No, there isn't.
Okay, so the only thing on there, just to be clear for the court, is the recording of Lori Vallow being served with Idaho papers.
That is correct.
Okay. Your Honor, I move for the admission of State's Exhibit 205.
Any objection?
No.
Okay. I request permission for the admission if I missed that, and then I request permission to play it for the jury.
It's admitted without objection, and it may be published.
Thank you, Judge. Your Honor, it appears the court system isn't connecting with the laptop. We'll try a different laptop, and then we'll do it again if you don't mind, because it's not displaying what it should be displaying from the laptop.
Okay.
Let's try another laptop. I'll get mine.
Range, I think I got it.
There's always a step ahead. Thank you. Thank you, Your Honor.
Do you have any questions regarding that? So it is 14:39 hours on January 25th. Any questions? Do you have any questions for that? No? Okay. I have next. Have a nice day.
Now, sir, those papers, were they part of an investigation into missing children?
Yes, ma'am.
And there were orders on the defendant to produce J.J. Vallow?
Yes.
Okay. And that was the service we just saw
Yes, ma'am.
of an order on Lori Vallow to produce J.J. Vallow?
Correct.
What date was that again? I apologize. I'm not sure I got the specific date.
It was served on January 25th, 2020.
Did you have any additional connection with the investigation into finding J.J. Vallow and or questioning Lori Vallow?
Yes, I did.
What was your next involvement?
My next involvement is I was assigned to execute search warrant.
Okay. And search warrant on what?
On the person of Lori Vallow, the person of Chad Daybell, a vehicle, and the condo.
Okay. And what date did you, were you part of a search warrant team?
Yes, ma'am.
Okay, so you weren't by yourself?
No, ma'am.
What date did you guys execute the search warrant involving Lori Vallow in Hawaii?
On January 26th.
The next day?
Yes, ma'am.
Okay. And so when you went to execute that search warrant, where were they found?
They were found driving a vehicle southbound from Princeville towards Louis, which is about a 30-minute drive, and they were going to Kauai Beach Resort.
Okay. And how was it law enforcement came into contact with Lori Vallow and Chad Daybell?
As far as, like, the traffic stop?
Yes.
Yes, ma'am. There was a traffic stop initiated at Kauai Beach Resort.
Okay. And so at the traffic stop, who was driving the car?
Lori Vallow.
Okay. And who else was in the car?
Chad Daybell.
Okay. At the traffic stop, was anybody, taken out of the car?
Yes.
Okay. Who was taken out of the car?
Both occupants, Lori and Chad.
Okay. At any point, was Ms. Vallow given an opportunity to receive her personal paperwork or her personal items?
Yes, she was.
Okay. Can you tell us about how that happened?
So we provided her with a copy of the search warrant, and then we allowed her to take some items that she might need, such as her cash or if she had any medication or anything like that.
When you say we, who's we?
Myself, Detective Cataluna, and Lieutenant Collio, and there was some other people there.
Okay. So when you allowed the Lori Vallow to obtain some of her personal paperwork, where did you guys go to, where did you locate that paperwork?
At her vehicle.
Okay. Was she present?
Yes, she was.
Okay. What paperwork or items was she trying to have you give her?
Well, we were just going to give her back her cash from her purse and give her back some items that she might, I think she had some medication in there. And then because we had the search warrant, we looked through her purse and then we put it back in the car.
Okay. So as you're looking through her purse, did you find any credit cards or any information?
Yes.
What information or credit cards did you find?
So Detective Cataluna was looking through her credit cards and counting her money, and when he was looking through the credit cards, he handed them to me to put inside a plastic bag to give back to Lori whatever he didn't need for the investigation. And then when he passed them to me, I looked through them again, and I saw one with the name. I saw a credit card with the name of Tylee Ryan.
Okay. So when you found the items with the credit cards and the card with Tylee Ryan's name, did that stick out to you?
Well, yes, it did.
Okay, why?
Because she was part of the missing children that we were helping them look for.
Okay. So what did you do with the card that was in Tylee Ryan's name?
That was held back, and then I put it back in the car.
Okay. When you say held back from the stuff that the defendant was going to be allowed to take herself?
Yes, that's correct.
Okay. And you put it in the car. Where did you put it in the car?
On the front seat.
Okay. And then was the car itself searched after the defendant was given some personal effects?
Yes, ma'am, it was.
Okay. And was that search documented in any way?
Yes, it was.
Okay. How was it documented?
It's documented. We execute the search warrant, and then we recover whatever evidence that we need for our investigation. We bag it and tag it, put the report number, and there's a property number that goes on there, and then I sign my initials on there.
Okay. And does anybody take any effort to take photographs of that process?
Yes.
Okay. And were photographs taken of the search of Lori Vallow's car in Hawaii on January 26, 2020?
Yes, ma'am.
Okay. And have you had an opportunity to look at those photographs?
I have.
Okay. Let me hand you what has been marked State's Exhibit 234Z. I apologize, 234A through Z, a copy of which has been provided to the court as a courtesy, and a courtesy copy has been given to defense counsel before today.
Can I clarify one thing?
One moment. We'll do that in just a second. Okay.
And in the A through Z, are there any missing letters in there, Ms. Smith, just to clarify? I didn't look yet. I'm just...
I don't believe so, Judge, but sadly crazier things have happened.
I've got all of them in my...
Okay, good. I believe all of them are there, Judge. I did double check. Do you need water?
Oh, I have.
Okay. Before you look at those, there was something you requested to clarify. What would you like to clarify?
I wasn't sure what the date was that you said on the execution of the search warrant for the vehicle.
What is the date for the execution of the search warrant?
That was done on January 28th, so 2 days after.
Okay, thank you. Take a look at State's Exhibits 234A to 234Z. Do you recognize those? And please look at all of them as a group. Do you recognize each one of those items in State's Exhibit 234A?
Yes, ma'am, I do.
Okay. How is it that you can recognize those pictures or the objects in those pictures?
The objects in the pictures I recovered while I executed the search warrant.
Okay. So was it your responsibility to obtain the evidence that's depicted in those pictures?
Yes, it was.
And then what did you do with the items that you collected?
They were bag and tagged, sealed with evidence tape. My signature was put on them along with the report number and a property number, and then they were turned into the evidence locker.
Okay. And when you located those items in the car, do the State's Exhibits 234A to 234Z both depict the location of where you found those items?
Yes.
And are true and accurate depictions of some of the items you found?
That is correct.
Okay. I move for the admission of State's Exhibit 234A to 234Z, Your Honor.
Any objection?
No, Your Honor.
Okay.
All right, exhibits 234A through Z, which contain each of those alphabetically, are all admitted.
Okay. Thank you. I request permission to display for the jury.
You may publish that.
That was loud. All right. Let me show you what has been marked state and admitted as State's Exhibit 234A. Let me zoom that out. What is reflected in State's Exhibit 234A?
The rental vehicle of Lori Vallow and Chad Daybell, 2019 black Ford Explorer.
Okay. And where is the car located when these pictures are taken?
The car is located inside the evidence warehouse.
Okay. And is that where you did the search and collected the evidence?
Yes, ma'am.
Okay. What is depicted in State's Exhibit 234B?
That's the front driver's seat of the vehicle with her purse on the front seat.
Okay. Now, you had mentioned you had put the credit card or the card of Tylee Ryan back in the car. When you put it back in the car, where did you initially put it?
On the front seat.
Okay, near her purse?
Yes, ma'am.
Okay. And is it visible in this picture?
No, it's not.
Okay. What happened to the card of Tylee Ryan after you put it back in the car?
I presume that it slipped to the side when I was loading the car on top of the tow truck for the evidence tow.
And why do you presume that?
Because I had it on the front seat, and then I jumped in to assist with the tow, with the evidence tow, and then it was later found on the little in between the driver's seat and that in the bottom of the door.
Let me show you what has been marked as State's Exhibit 234C. What's that?
That's a more close-up shot of her purse.
Okay. And State's Exhibit 234D, what's this?
That's a partial view of the credit card that fell from the front seat to that door jamb area.
Okay. So the credit card had been in Lori Vallow's purse?
Yes.
And then it was taken out, you identified it, and then it was put in the car?
Correct.
And then it slipped between the seat and the door?
Yes, ma'am.
And that's a picture of where it landed?
Yes, it is.
Okay. What is State's Exhibit 234E?
That's the...
Can you see that? What is that one?
That's the credit card.
Okay. And the name on it, the light reflection is not.
It's Tylee Ryan.
Okay. In State's Exhibit 234F. Just get that down.
That's the back of the same credit card.
Okay. And what do we see in State's Exhibit 234G?
Lori Vallow's cell phone that was found in the side pocket of her purse.
Okay. And was that cell phone seized?
Yes, it was.
And then what did you do with the stuff you seized again, just so we're clear?
They were what we call bag and tagged. Evidence tape is put on there. They're photographed, and then they're submitted into the evidence locker.
Okay. And was the items eventually shipped and given to the Rexburg PD?
Yes, they were.
Okay. State's Exhibit 234H. What are we looking at here?
That's the rear passenger side of the vehicle, and there's on the bottom of the floorboard you can see a blue and white striped bag. That's a Robin Ruth bag that was recovered.
Okay. When you said that was recovered, did you find anything of potential evidentiary value in that bag?
Yes, I did.
What did you find in that bag?
That bag had several personal documents. It had birth certificates, death certificates, had, I believe, a marriage certificate, had a rental agreements, and patriarchal blessing, and
a lot of items in there?
Yes, ma'am.
Okay. So did you take that bag and seize it?
Yes, I did.
And did you seize its contents?
Yes, I did.
Okay. For completeness sake, what is State's Exhibit 234I?
To the left of the door on the far left-hand bottom corner, that's another picture of the bag on the floorboard.
So when you say in the far left corner of the image?
Yes, ma'am.
Okay, and so just so that I'm clear, it's this?
That is correct.
Okay. What is reflected in State's Exhibit 234J?
That's the rear cargo area of the vehicle.
Okay. Did you seize anything that you felt might be of significance from the rear cargo of the vehicle?
Yes, I did.
What did you seize?
There was a black JanSport backpack, and inside of that backpack, I seized 2 computers.
Okay. All right. Now, you mentioned the blue bag from the back seat. Is that what we're looking at in State's Exhibit 234K?
Yes, it is.
And then you indicated that you seized the items from the blue bag. Please tell us what's in State's Exhibit 234L.
There's a couple folders that have a lot of those personal documents, and two Apple laptops. There's actually 3 all total in that bag, and then there's a book and a couple other folders.
Okay. Is State's Exhibit 234M a copy of one of the Apple products that you seized? An image of one of the Apple products you seized?
Yes, it was.
In State's Exhibit 234N, is this another one of the Apple products you seized?
Yes, it is.
And that were conveyed to Rexburg PD for analysis?
Correct.
And State's Exhibit 234O, is this one of the other devices you seized?
Yes, ma'am.
Okay. And what initials are in the back of that device in the otter box?
JJ.
In the red letters?
Those are yes.
Okay. And State's Exhibit 234P, what is that?
That's the front of that same Apple tablet.
Okay, and that Apple tablet with JJ's name on it, that's the front of it?
Yes, correct.
Okay. Now you mentioned some personal papers.
Yes.
Okay, pour your water. I'm with you. You need a drink?
No, go ahead.
Okay. Let me show you what's in State's Exhibit 234Q. What are those?
Uh,
Are those some of the personal papers you seized?
Yes, it is.
Okay. Do you need me to zoom in to be able to see which ones?
Yes, please.
Okay. Let's start with the image that's on the left side of the picture. Can you see that?
Honestly, no, I cannot read the...
Need me to zoom in? You need me to zoom in?
Well, when it does, I think it gets blurry, so I can't see that. Okay.
Let me do it one more time.
Okay.
Can you read it?
Yes.
Okay. What is the document on the left side of the picture?
On the left side of the picture, it's State of Arizona Certificate of Death, named in the name of Leland Charles Anthony Vallow.
Okay. And so that's a death certificate for Leland or Charles Vallow?
Correct.
Okay. How many copies did you find of Charles Vallow's death certificate in Lori Vallow's rental?
There was roughly 14 or 15 copies.
Okay.
Excuse me.
That's all right. And what is the document on the right-hand side of the picture?
That's a document of the condo complex that they were staying at.
Okay. What do we see, what are the papers we see in State's Exhibit 234R? And do you need me to zoom out?
Just a little bit. Can you push the one on the left down just a little bit so that the top is showing? There you go. So that's a State of Louisiana certification of birth in the name of Joshua Jackson Vallow.
Is there an additional certification of death on the very right-hand side of the picture?
Yes, there is.
Who is that for?
It's issued by the State of Arizona in the name of Leland Charles Anthony Vallow.
And that's another one of the copies you found?
Yes, ma'am.
Okay. There appear to be some Social Security cards in the picture. Let me move it over. Can you read those?
Yes, I can.
Whose Social Security cards were in that car in Hawaii?
Tylee Ryan and Joshua Vallow.
Okay. And the investigation was into a disappearance into both Tylee and JJ, correct?
Yes, that is correct.
And the paperwork served on Lori a couple of days before this search was for her to produce both Tylee and JJ?
That is correct.
Okay. above, in the image, above the Social Security cards for JJ and Tylee, it looks like there's some school paperwork.
Yes.
Okay. Can you tell us what that says?
It's a receipt from the Madison School District in the name of received from Joshua Vallow.
And at the top of the image, if you can read it, what do we see? You mean zoom?
Yes, please.
Is it still too blurry?
No.
Can you read it?
Yes. Department of State Health Services vital statistics. Okay, I can't really read that last word, but it's in the name of Tylee Ryan.
And then there were some items in a bag in the picture. Can you see what those are?
Yes.
What were those?
State of Louisiana certification of birth in the name of Kanan Trahan.
Okay. Which of the papers do we see depicted in State's Exhibit 234S? And I'll zoom out. Can you read those?
Yes, I can.
What are those?
Certification of birth issued by the state of Louisiana in the name of Kanan Trahan.
Do you remember how many copies of JJ's birth certificate under any name, Kanan Trahan or JJ Vallow, were in that bag?
There were several. I don't know how many offhand.
Okay. Of the papers from that car, what do we see in State's Exhibit 234T? And I'm going to zoom out unless you need me. Can you read that?
Yes.
What is that?
That's a Blue Sky Property Management Residency and Financials document for a lease agreement in the name of Lori Vallow, Tylee Ryan, and Joshua Vallow. It looks like it's dated 8/26/2019.
And at the very top, that address is in Idaho? If you can read it.
Yes, Rexburg, Idaho.
And in State's Exhibit 234U, let me zoom out a little bit. What are we looking at here?
That was a patriarchal blessing from Chad Daybell to Alexander Cox, dated November 24th, 2019.
And that's just a copy of the front page?
Yes.
Now, turning to that black JanSport bag, is this what we see in State's Exhibit 234V?
Yes.
Okay. In State's Exhibit 234W, there's an image there. What is that?
It's a plastic bag containing an envelope with U.S. currency.
Okay. Where did you find that?
Inside the backpack.
Okay. And in State's Exhibit 234X, what is this?
That's a patient clinical summary with a bunch of sticky notes on it.
Okay. And can you read the names at the top? Or do you need me to zoom in?
The top of the summary or the sticky notes?
I'll ask a better question. The top of the typed paper.
I can't read. Excuse me, I can't read the name on that. Lori Vallow.
Okay. And then you indicated there's some stickies. It's the blue stickies we see in the picture?
Yes.
Okay. Did you see any of the information on those?
I don't know what any of those mean.
Okay. Are there various words?
Yes.
Okay. Starting at the bottom, do you see, what's the word at the words at the bottom? Can you read it?
I'm not. I can see it, but I don't know what that word is. If it says gens or.
Judge, I think that I'm going to object here. I think that the exhibit speaks for itself. He doesn't know what it is. He doesn't know anything about these specific words on this page. So I think that has lack of foundation for him to be able to testify as to what these things are.
Well, the exhibit speaks for itself, so I'll sustain it on those grounds.
Okay, for the completeness of the record, can I ask him to read the words he sees without saying what it means? Or I'm not asking him to speculate.
Well, the exhibit's admitted. If there are certain words that go towards your direct, you can ask on those.
Okay, thank you. The sticky note down here, can you read the words?
Objection, leading.
Overruled.
Thank you, Judge. Can you read the words?
I can read Blake and Hilpus.
Okay. And then there's a sticky note above that. Does that appear to be the word Brandon?
Objection, leading.
Sustained.
What's the word you see above that?
Brandon.
Okay. And do you see a word below that?
Yes.
And if you want to spell it, that's fine.
ANGO.
Okay. And then there's a sticky note above the name Brandon or the word Brandon?
Yes.
What is that?
Golmad and twice. One written in cursive and one written in regular print, and the word hope.
Okay. And then there's sticky notes to the left side. Is that the word Brighton?
Objection, leading, Judge.
I was just trying to move it forward, Judge. I can ask him. Can you read that word?
Yes, Brighton.
Okay, thank you. And do you see, if you need to spell it, do you see words below that?
ILRON.
Okay. And then there's a sticky note down below. Can you read that?
I cannot read that one. I can read the one below it.
Okay.
Judge, I think now we're getting into a point where she's blowing things up to a point where it's being prejudicial.
Well, unfortunately, Judge, with the lighting in here, it's hard for him to see. Can I have him handed the hard copy?
Yeah, there's also a light on that projector that I think can be used. And I'll overrule that objection. I don't find it's prejudicial to try to.
Oh, thank you. Does that help you see it, or would seeing the original be better?
Seeing the original would be better. I can't decipher that, and honestly, my eyes are pretty bad.
Okay. May he be handed back States Exhibit 234X?
Yes.
Okay. You able to see it?
No, I'm sorry. I can only see the bottom one.
And the bottom one is?
Gladius.
Okay. Thank you. May I have that back? Thank you. And two more. States Exhibits 234Y. What are those? Let me zoom out. What are those?
It's a Apple laptop, MacBook, and a HP laptop.
Okay. And those are the laptops you said you seized from the black backpack?
That is correct.
And those were turned over to eventually to Rexford PD for analysis?
Yes, they were.
Okay. And State's Exhibit 234Z, do you recognize this?
Yes.
What is that?
It's the backside of the HP laptop.
One moment, Your Honor. Let me check with co-counsel, but I think I'm done.
Okay.
One last question. Did you also participate in the search of a condo where Lori Vallow and Chad Daybell were living?
Yes, I did.
And in that search, did you find anything of evidentiary value?
Yes, I did.
What'd you find?
Two separate items that were, one was a Agnaro brand silicone-like rings, and then there was another bag, I think it was Thunderfit rings, silicone rings.
Okay. Any evidence that there were children there?
No.
I have nothing further.
All right, thank you, Ms. Smith. All right, given the time, then we will go ahead and take the lunch recess. We will plan on returning just right around 1 o'clock or maybe 5 to 1 o'clock. Thank you.
Thank you.
All right, please.
It lost connection for a minute. It lost the signal when it didn't turn.
Okay, so we'll be returning at 1 o'clock. Please grab all your property. You can leave chargers, cushions, and all that to go.
Thank you. Let's have the jurors brought in, please.
right, please. Jury's out, President Chapter 4, Your Honor.
Thank you, Mr. Bailiff. Please be seated. Okay, we're back on the record on case CR 22-21-1624, State of Idaho versus Lori Noreen Vallow. We just took our lunch break. Ladies and gentlemen of the jury, I know that break was longer than anticipated. I've been working with the attorneys to sort through some upcoming issues in the case that needed to be dealt with outside of your presence. I'll also indicate that after discussion with counsel, the scheduling we've got here is going to be as follows. So we'll end up, we've got another witness this afternoon. Will likely be done before 3 o'clock today. Tomorrow, given the status of where the state's case is with their witnesses and timing of other considerations and an argument we need to take up in the morning as well, we'll have a shortened day tomorrow, and we'll intend to go through evidence tomorrow until about noon. And then next week we'll be back on Monday for the regular typical trial schedule. So that's how we anticipate the week working out in terms of evidence being presented. So once you're excused for the afternoon today, the court will intend to hear argument on an additional motion that you don't need to be here for, so we'll let you go home for the day, and then in the morning we'll resume with half day tomorrow. So just from the state, is that the state's understanding of what we determine on an appropriate trial schedule?
Yes, Your Honor.
All right, does the defense agree?
We do.
Okay, thank you, counsel, for that. With that in mind, then, if we could have the witness return to the stand. Okay, at this point, I believe we're going to commence with cross-examination, and who's going to be doing that?
I'll be doing that, Judge.
All right, Mr. Thomas, you can go ahead and start your cross. I will remind the witness, detective, you're still under oath for your testimony.
Yes, sir.
With that in mind, Mr. Thomas, when you're ready.
Good afternoon, Detective.
Good afternoon, sir.
It's Detective, right?
Yes, sir.
How long have you been a detective?
I've been a detective for 7 years.
7 years. All with the same department?
Yes, sir.
Okay. And we went through a couple of things. There was a video of you walking into a pool area with somebody else. Who was the other person that was with you?
Detective Chad Cataluna and my lieutenant, Christopher Collio.
Okay, so the three of you?
Yes, sir.
All right. And the purpose of that was to serve an order on Ms. Daybell, is that right?
That is correct.
Okay. And she was to produce some children?
Yes, sir.
Okay. And then 2 days later, you indicated that there was a warrant to search her vehicle, is that right?
That was be 3 days later, the 28th.
3 days later, sorry. And that was a warrant to search her vehicle?
Yes, sir.
And what was the purpose of that warrant? I mean, I know the purpose was to search the vehicle, but what were you looking for?
Any evidence for, I wasn't the one that wrote the warrant, so the person, Detective Cataluna, wrote the warrant, and then he had to do another operation, so he passed that on to me, and I served the warrant.
Okay. But what were you looking for?
Any evidence for the missing children?
Okay. And so when you pulled the people out of the car, I believe you indicated that there was, I want to say, a Robin Ruth bag. Is that right?
Yes, sir.
Is Robin Ruth, is that some sort of a name brand?
I don't know.
How did you come up with Robin Ruth?
It's on the bag.
Oh, okay. All right. And were you the one that was doing the actual search? Was it you and some other people, or just you, or?
I did the actual search, and then I had a bag and tagger and a recorder and a photographer.
Okay. So a bag and tagger, that's a person that takes the evidence that you collect, puts it in an evidence bag, seals it up, and marks it and tags it as far, putting it on some sort of a inventory?
Yes, sir.
Okay. And who was that?
That would have been Detective Brandy Ledesma.
Okay. And some of the things that you found, I'd actually like to take a look at Exhibit 234, if I could. And can I publish that to the jury, Judge?
Yes.
Parts of it? So tell me, this is Exhibit 234B. Can you tell me what you can see in that photo?
Well, I see several things, but mainly the purse.
Okay. And did you collect the purse as evidence?
I don't recall if I collected the actual bag.
Okay. You were looking for evidence of the kids, right?
Yes, sir.
Did you take any trace evidence in the car?
No, sir.
None. Okay. I'm now going to show you 234D. D is in dog, I believe. Let me check that. D. And what is this picture of?
That's the picture of the credit card that I inadvertently knocked off the seat.
Okay. And you had somebody take a photo of that?
Yes.
Will there be any trace evidence near or around that credit card?
I don't know.
Do you see anything in there that might be considered trace evidence?
Yes, I see some hairs.
Do you think maybe some of those hairs could have been Tylee's? Do you think that might have been something that you would maybe collect?
That is a great possibility.
If you were actually looking for a child, would that be something that you would try to collect?
Yes.
But you didn't do that?
No, sir.
Okay. $234K, what is that?
That's the Robin Ruth bag.
All right. And this was, where did you say you found this, in the back seat?
On the rear passenger side floorboard.
All right. And this is where they kept most of or all of the important documents that you found?
Yes, sir.
Okay. And this is another photograph of the bag, is that right?
That is correct.
Okay. This is 234L. Those were some of the important documents that you found inside the bag?
Yes, sir.
Okay. You found a couple of iPads, it looks like?
Yes, sir.
There was a book, it looks like a religious book. Do you know anything about that book?
No, I do not.
Okay. And then some other papers and whatnot?
Correct.
Okay. And these are some, but not all, of the important documents you found in that bag, right?
Correct.
Okay. There were other important documents that you just didn't photograph?
Not that were everything that was taken as evidence was photographed.
Okay. Was there, okay, so these were all the documents, so to speak, that were vital records and those kinds of things. Those were the only ones that you found?
No, there's some more.
There are more?
Yeah.
Okay. Are you talking about this one?
That is one.
Okay, but that was also included in the other exhibit, right? Certificate of live birth? Or no, you're right. I'm sorry, you're right. That was a different certificate of birth. All right, so this is one of the documents that you said that were also in there?
Yes, sir.
Okay. Was this document in there as well?
Yes, sir.
In the bag that had all the important documents in it?
Yes.
Okay. Was this the only page that was in there, or was it several pages?
I do not recall that.
You don't recall?
I apologize, counsel, for the record. What picture is that?
This is 234U. If I can just have a second with counsel, Judge.
Yes, you may.
Did you photograph every page of this particular document?
I don't recall if there was more pages of that document or not.
Okay. But this was a photograph that was taken as far as you know?
Yes.
And was this... Okay. But you don't know if there were other pages, but you don't know if there were other pages to this document?
I don't recall offhand right now, no.
Okay. And this is document 234W. You said that was purported to be some cash?
Yes, sir.
Okay. How much cash was it?
It was roughly $5,000. Might have been a little bit more, in between $5,000 and $5,500.
Okay. And the state had you review this document and you read these names off?
Correct.
Okay. You don't know what any of these names mean?
Possibly Hope.
But you don't know what any of these names mean?
Not the other names.
They don't have any, in your investigation, the names haven't come up? You don't know if they're spiritual names or some sort of anything like that?
I don't know what they stand for.
Okay. What you know is that all those documents came out of that one bag?
Correct.
And those are very important documents for those people?
Can you repeat the question?
That those were important documents to the people that own that bag?
I suspect.
Okay. Okay. We have nothing further, Judge.
All right, thank you, Mr. Thomas. Redirect.
No, sir. Thank you. Very briefly, Your Honor, I apologize. 2 questions being asked. I should have answered you first. Sorry.
Oh, that's fine.
Good afternoon, Detective.
Good afternoon.
Couple just quick questions. When you searched, defense counsel asked about your search of the car and trace evidence. Do you remember those questions?
Yes.
And so in reviewing and executing the search warrants, let's start with the condo. Did you find any evidence that there were children staying in that condo?
No, I did not.
Okay. When you looked at the car, how many bikes were in that car? Would looking at the pictures be easier for you?
Yes.
Can I have State's Exhibit 234, please? Thank you, sir. Appreciate it. I'm putting State's 234J up there. How many bikes do you see in the back of that car? Do you need me to rotate it for you?
No, that's fine. I see one.
Okay. And was that bike spread out into the car, or was it totally in the trunk?
It was totally in that cargo area.
Okay. And let's take a look at State's Exhibit 234H. How many bike tires do you see in that car, in that picture?
2.
Okay. And they were spread out across the back seat?
Yes, ma'am.
Okay. Any evidence that there were children in that car?
No, ma'am.
Okay. In fact, when the car was stopped, how many people were there?
2.
Okay. And who was that second person?
Chad Dabo.
Okay. There were no children at that car stop?
No, ma'am.
Okay. And looking at the pictures, there's no place for a child to even sit, is there?
No, there's not.
Did you find any evidence at any of the scenes you went to, either by the pool, where you saw Ms. Vallow sunbathing, or in the rental car that the Daybells rented, or at the condo? Did you see any evidence that JJ and Tylee were there?
No, I did not.
Did you see any evidence that they'd ever been there?
No.
Thank you. I have nothing further.
All right, that'll conclude the testimony of this witness then. May this witness be excused and released from any subpoena.
We would ask that he is, Judge.
Thank you.
No objection.
All right, no objection, then you're released, and thank you for your testimony. You're welcome. The bailiff will assist you in exiting the court. All right, the state may call its next witness.
Thank you, Your Honor. The state will call Ryan Pillar, Officer Ryan Pillar.
Or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
All right, before we commence with testimony then, I will inquire of the witness who's now under oath, Officer Pillard. Have you reviewed, read, or listened to any of the trial testimony at all that's taken place since this trial began?
No, sir, I have not.
Okay. With that then, you can conduct your direct examination. I would request that the witness talk directly into the microphone, make verbal responses to any questions asked so we keep a clear record, and try to avoid speaking at the same time as any attorney questioning you. Ms. Smith, you can go ahead and inquire on direct.
Thank you, Judge. Good afternoon.
Good afternoon.
Can you please identify yourself to the ladies and gentlemen of the jury and spell your last name?
Yes, my name is Ryan Pillar. Last name is spelled P as in Paul, I-L-L-A-R, first name R-Y-A-N.
And, sir, how are you employed?
I'm employed with the Town of Gilbert Police Department, located in Maricopa County, Arizona.
Okay. How long have you been a police officer in Gilbert, Arizona?
I was hired in February of 2007, which brings me to a little over 16 years.
Okay.
Prior to going forward, I would lodge an objection as to 404B. I know that the court has ruled on that, but to preserve our record on appeal, we'd like to object to him testifying pursuant to 404B.
Okay. Ms. Smith, I understand the objection. Is there anything the state would like to add before the court makes a ruling on that?
No, Your Honor. The court we took this matter up before the court in advance, and we understand the court's rulings. And this witness will have some evidence that is 404B, but he is also part of a sort of joint law enforcement effort to find the kids. So partially there will be 404B, and partially there will be stuff relevant to this investigation.
Okay. The court's considered that objection then for the jurors. We keep using this term 404B, which is just an evidentiary rule, so you don't need to be concerned about the number, simply that you will be instructed on what evidence is to be considered and how, and you've previously been instructed on this type of evidence. You will be again at the time of your deliberations. The court will overrule that objection as it relates to any 404B evidence, noting that any previous hearing that was decided by the court that this evidence would be admissible for a limited purpose. And with that in mind, and for the reasons I indicated in that February ruling incorporated into this decision, the objection is overruled. And Ms. Smith, you can commence with your direct examination.
Thank you. I believe you indicated you were a police officer in Gilbert and you were there for 16 years. Did I hear that correctly?
That is correct.
Okay. Can you tell us a little bit about your training and background?
Yes, I attended 18 weeks of the Arizona Law Enforcement Academy, followed by another 18 weeks of field training in the field while working as a police officer in Gilbert. I worked on patrol shift, working both day shift, swing shift, and night shift throughout 9 years. In August of 2016, I made a lateral movement from patrol to our special victims unit, which is a detective unit designed to investigate crimes against children and sex crimes. In August of 2019, I laterally moved from the Special Victims Unit to the Violent Crimes Unit, where I was responsible for investigating violent crimes to include but not limited to robberies and homicide. And then in August of 2021, I made a lateral movement back to patrol to pursue some other avenues within the Gilbert Police Department.
Can you tell us a little bit about your training that supports your experience as an officer in Gilbert?
Yes, through Arizona Police Officer Standards and Training Board, I've attended hundreds of hours of continued training. Some specific training would include a 40-hour forensic interview training. I've attended a 5-day homicide investigation training, a 5-day child crimes and sex crimes related training, and multiple interview and interrogation type training. Also, I have attended some 40-hour course on evidence collection and identification for crime scenes.
Now, in your capacity in for the violent crimes investigation, did you become involved in an investigation into an attempted shooting at a gentleman by the name of Brandon Boudreaux?
Yes.
What was the date of that attempted shooting?
October 2nd, 2019.
Okay. How did you become involved in that situation?
I was working as a detective at that time. I was actually in a meeting with fellow detectives, and we were notified of a shooting that occurred in the area of 3875 East Phelps Street in Gilbert. And as the Violent Crimes Detective Unit, we responded to further investigate that scene.
What did you find when you got there?
Upon arrival, the Phelps Street runs east and west, and the crime scene tape was set up with police vehicles to prevent any type of further contamination. At the address of 3875 East Phelps was a black Tesla with Arizona license plate that ultimately returned to Mr. Brandon Boudreaux. Brandon Boudreaux is also present at the scene. He is the resident and the individual who was shot at and called 911.
So once you were at the scene, what steps did you take?
I was assigned the primary investigator. I then delegated tasks to my fellow detectives to include collecting evidence at the crime scene and canvassing the area, while I tasked myself with interviewing the reporting person / victim, Mr. Brandon Boudreaux.
Were you able to interview Brandon Boudreaux?
Yes.
Was he cooperative?
Yes.
Okay. What, if any, information did you learn that caused you to take steps, further steps in investigation?
So speaking with Brandon, I ascertained what he did that morning. So I learned that morning he left his residence with his 4 children in common with his wife at the time, Melanie Boudreaux. And he took his 4 children, 3 of them to school, and another child, their youngest, to meet with Melanie at another residence in Gilbert. Brandon then met with his friends to go to the gym, and then returned to his residence at 3875 East Phelps in his vehicle. As he drove towards his residence, he observed a gray-colored Jeep Wrangler.
I'm going to object to this testimony as being hearsay. These are all things that Mr. Boudreaux apparently said.
Well, Your Honor, I apologize. I'll let you.
I will sustain that in terms of the specificity of what was stated there by Mr. Boudreaux.
Okay. So what information did you learn from Mr. Boudreaux that led you to take any investigative steps?
After he returned home, he was shot at, and then we conducted a canvass of the area and spoke with neighbors, collected ring footage, and ultimately confirmed that there was a Jeep that was idling in front of Mr. Boudreaux's residence for approximately 1.5 hours. That Jeep was described by Brandon and by independent witnesses as well as ring footage as a gray-colored Jeep Wrangler with a Texas license plate. Additionally, that Jeep did not have a wheel affixed to the back of the Jeep Wrangler.
Why was that significant?
Jeep Wranglers, two-door Jeep Wranglers specifically, have wheels on the back that would prevent the back window from being able to be opened. In Mr. Bedreau's interview, he explained that when he approached his house, the back window of the Jeep opened up.
Again, I'm going to object to hearsay.
It's to explain. I'm sorry. Counsel, go ahead.
He's indicating what Brandon Bedreau told him.
Okay. Your Honor, it's not for the truth of the matter asserted. It is to show why this officer made the observations he did and then what steps he took next based on what he received.
Okay. I'll overrule the objection, but instruct the witness to try to avoid making direct quotes of what was told to you by someone else in the course of the investigation.
Okay. Thank you, Your Honor.
Yes, sir.
So you were explaining the relevance of the Jeep window?
Yes, I'm sorry, ma'am. So the Jeep window cannot open up if that wheel is affixed to the back of the Jeep Wrangler. If that wheel is not present, in this case, the window is able to be opened up. Again, with ring footage and independent witnesses that were talked to at the scene, a gunshot was heard from that area at about 09:14 hours, which is when Brandon Boudreau returned home. Again, confirmed with witnesses and digital evidence.
So in addition to learning information about the presence of the Jeep, was there any other physical evidence that led to corroborate what you had learned from Mr. Boudreau and then led to you following up on that information?
Yes. There was a bullet hole in the front A-pillar of the driver's side door of a Tesla. So there was actually a bullet hole. I guess I can just describe it A-pillar, kind of towards the top of the driver's side door. The projectile fragments were recovered, some of them. After the shooting happened, Brandon called 911 and drove away from the scene. So we canvassed the area to look for other fragments, but ultimately the ones that were recovered were from the bullet hole within the vehicle. The windshield was also shattered, where Brandon explained where he was shot at. There was shards.
Your Honor, it calls for hearsay. He's saying what Brandon told him.
Well, that's sustained.
Okay. Were there shards of glass in any particular area of note to you?
Yes. So additional to the bullet hole, there were shards of glass in the roadway where it was believed Brandon was shot at.
Okay. And did you also, in addition to looking for physical evidence, did you learn any information that led you to investigate a possible motive for the shooting of Brandon Boudreau?
Yes.
What did you look at as a possible motive for shooting at Brandon Boudreau?
Brandon denied having any enemies or anybody who would want to
object to hearsay, Judge.
Sustained.
Okay. Without telling us what somebody said, if you could just give us what information you had that led you to lead somewhere else. Did you have any evidence to suggest at the time that Brandon Boudreau had enemies?
No.
Did you have any evidence that you obtained that indicated possible marital or spousal disputes?
Yes.
What information did you possess that suggested there was a spousal dispute or marital problems?
I learned that Brandon was in the process of a divorce with his wife, Melanie Boudreau, and learned that his aunt, Lori Vallow, had a brother, Alex Cox, who was involved in a homicide in Chandler, Arizona, the death of Charles Vallow. Chandler, Arizona is a sister city to Gilbert. We actually share jurisdictional lines. So when Brandon told me about his marital problems with Melanie, combined with the recent homicide, that furthered our investigation to look into communicating with Chandler police about what they investigated.
Were you able to reach anybody at the Chandler Police Department?
Yes.
And did you learn anything that led you to investigate the possible motive or potential suspects from Chandler Police Department?
Yes, it was learned from Chandler detectives that a homicide happened within their jurisdiction in July of 2019, where Charles Vallow was shot and killed by Alex Cox. And present at that scene was Lori Vallow, her two children, Tylee Ryan and JJ Vallow. Additionally, with meeting with Chandler PD, we learned of a gray-colored Jeep Wrangler with Texas license plates was present at their crime scene.
Did you learn who the suspected primary driver of that vehicle was?
The registered owner was Charles Vallow. However, his daughter, Tylee Ryan, was using that vehicle to and from school.
So upon learning this information, what steps did you do to follow up on the shooting of Brandon Boudreaux?
So upon learning this information, this Jeep became a primary piece of evidence for our shooting. So we checked LPR hits. LPR is an acronym for license plate reader.
And did that check of the license plate reader system yield any results?
Yes, it did.
What results were developed on the license plate for that Jeep?
Again, the license plate readers revealed that the Jeep Wrangler with the Texas license plate, and I can't recall the license plate right now, I have it in my notes, but the license plate was captured traveling southbound from the area of Idaho Falls on 9/30 of 2019, continued southbound in the area of Holbrook, Arizona, which is northern Arizona, on October 1st, 2019, and then that Jeep returned to the area of Idaho Falls on October 3rd, 2019. Brandon's shooting occurred on October 2nd, 2019.
And each of those places where it was located was based on description and actual license plate reading?
Yes, so a license plate reader runs specifically off of the plate itself. Of note, one of those cameras was a DEA camera, a Drug Enforcement Agency camera. They are along different highways. And it captured an image of the Jeep driving southbound towards the area of Phoenix metro area. The Jeep did not have a wheel affixed to the back of the Jeep. There was no wheel on it.
Upon receiving this information, upon receiving this information about the license plate reader, did you take any steps to reach out to any other law enforcement agencies, specifically in Idaho?
Yes.
What agency did you reach out to?
Initially, Fremont County Sheriff's Office was contacted. This was in conjunction with another death that was learned. So based on a death that was learned of Tammy Daybell, that combined with the Jeep being up in the Idaho jurisdiction, we contacted Fremont County Sheriff's Office and then communicated with Rexburg because we gained information that an address was being utilized off of Pioneer Street in Rexburg, Idaho. And we began to suspect our Jeep was somewhere within Fremont County or Madison County.
So when you say another homicide, did you learn information that Tammy Daybell had passed away?
Yes. Again, I had regular communication with Mr. Boudreaux. He reached out and notified me of a death of Tammy Daybell.
Why was that relevant to you in your investigation?
Because according to him,
Objection, Judge, this is calling for hearsay testimony.
Agreed, that would be hearsay.
Did you have a reason to believe that any of the people of interest in your investigation in the shooting into Brandon Boudreaux had also had a spouse who passed away within proximity to the time when Brandon passed away?
Yes, there was information that Lori Vallow and Chad Daybell had a relationship in Idaho, and Chad Daybell's wife, Tammy Daybell, died near the time of Brandon's shooting, shortly thereafter. So I contacted Fremont County Sheriff's Office where Tammy's death occurred. I spoke with a coroner up there to discuss how the process works for death investigation in that county. And also we inquired about the Jeep we suspected to be in the area.
Were you able to contact any other law enforcement specifically to help you locate that Jeep?
Yes, we made contact with the Rexburg Police Department, and communication began directly with Detective Hermosillo.
Okay. And when you say communication, specifically about what?
About our Jeep, and we were looking for our suspect, Alex Cox, and we believed he was up in that jurisdiction.
Okay. So when you say your suspect, Alex Cox, at this point, why was Alex Cox a suspect in the shooting of Brandon Boudreaux?
We completed search warrants for cellular tower data and cell phone data, and it revealed that Alex, one of the phones he was using, was traveling within the area of Brandon's residence and actually was parked in front or near Brandon's residence during the time of Brandon's shooting, and then left the area shortly thereafter and back towards Idaho.
And so understanding that you had a person in interest or a suspect, were there other individuals you were interested in as well?
Yes, his wife, she was still his wife at the time, Melanie Boudreaux, and then, of course, wanting to talk with Lori Vallow and check welfare of the children that were involved, which is Tylee Ryan and JJ Vallow.
When you say you wanted to check the welfare, what caused the department in Gilbert to want to check the welfare of, or the departments in Arizona, correction, to want to check the welfare of either JJ Vallow or Tylee Ryan?
So once communication was had with Chandler PD about their homicide and our attempted homicide, we communicated with the FBI to get some assistance with the cellular data analysis, because it's quite complicated in my opinion. I'm not a cell phone guru, so. Once communicating with them during that meeting, a big question arose of when was the last time either Tylee Ryan or JJ Vallow were seen, their welfare. So despite our desire to locate Alex and interview him and process the Jeep, of course, locate and process the Jeep, another focus became, let's check the welfare of these two minor children while conducting our further investigations.
Had either department in Arizona received information from any of their relatives looking for those children?
Yes, Kay Woodcock spoke directly.
Objection, hearsay.
Sustained.
What information, without telling us who said what information did you have that caused people to ask law enforcement to locate JJ and Tylee? Again,
I'm going to object as the only way that he can answer this is through hearsay testimony.
That'll overrule. I think the officer's allowed to indicate what he did in the course of his investigation based on generalized information received.
Okay.
So within this law enforcement meeting we were having, it was brought up that family members were concerned because they had not been able to see or communicate with either Tylee or JJ at all, via electronic means or otherwise.
And so with that information or conversation, was the request made back to Idaho to locate either of those children?
Yes. Prior to that request, the Jeep Wrangler involved in the Gilbert investigation was located at this Pioneer address, which Rexburg police were able to impound for future processing. Rexburg also assisted by then going to the Pioneer address where it was confirmed that Alex, Lori, and Melanie Boudreaux were living, and they attempted contact with those members and attempted to locate and check the welfare of Tylee and JJ.
And were they successful?
They were successful in contacting Alex, Chad, and Lori, but were unsuccessful in locating the children.
And so with Gilbert learning that they were unsuccessful in locating Tylee and JJ, what efforts or position did the Gilbert PD take in continuing their investigation?
We knew we had our Jeep for our shooting, but with the contact that Rexburg police had on October 26, 2019 with Alex Cox, Chad Daybell, and Lori Vallow.
I apologize, maybe I misheard you. Was it October or November of 20?
I'm sorry, November 26. I apologize. It was November 26 when this contact was made. It was relayed back to Gilbert police that it was told to them that JJ Vallow was in the custody of Melanie Gibb. Melanie Gibb was a close friend to Lori Vallow. Melanie Gibb additionally lived in Gilbert, Arizona. So the Gilbert Police Department, myself and a partner detective of mine, went to two respective residences where Melanie Gibb lived, and she was not at either location. Telephonic contact was attempted with Miss Gibb and unsuccessful. However, messages were left for her to return a call from myself. It was, I want to say, approximately 8 p.m. or 9 p.m. that evening where I received a call from Melanie Gibb.
Objection. It's going to be hearsay, whatever he's going to say next.
Sustained.
Okay. So did you learn information from Melanie Gibb that caused you to be concerned for the whereabouts of J.J. Vallow or Tylee Ryan?
And I'm going to object as to the only way that he can answer this is through hearsay testimony.
Yeah, that's not being offered for the truth of it. It's for the furtherance of the investigation. So on that, the objection on hearsay is overruled.
Thank you.
You can answer if you remember the question.
Can you please repeat the question?
Sure. Did you learn information from your conversation with Melanie Gibb that caused you to be concerned for the whereabouts of J.J. Vallow or Tylee Ryan?
Yes, I did. She told me she didn't have.
Objection, it's hearsay. He just said she told me.
Well, as to direct quotes, again, yeah, that would be sustained as hearsay, what anybody's directly quoted as having said to you. So, Ms. Smith, ask another question, please.
Did you learn information without saying what someone said? Did you learn information that caused you to be concerned for the whereabouts of J.J. Vallow or Tylee Ryan?
Yes, I did.
Okay. Did you continue to look for J.J. Vallow or Tylee Ryan in Arizona?
Yes.
Okay. Where did you look in Arizona?
So we set up poll cams at Melanie Gibb's residence because, again, we couldn't contact her and she was not in the state of Arizona during my conversation with her. So we set up poll cams, which are cameras that monitor 24/7 a specific location. We then began making contact with known family members and friends to both Lori and then friends that would have been in high school with Tylee at a point in time, as well as where JJ previously went to school.
Did those contacts yield any results in locating JJ or Tylee?
No, they did not.
Okay. Did you also communicate with any other law enforcement officers about that there's no evidence of JJ or Tylee in Arizona?
Yes.
And did you communicate that with Rexburg and Fremont?
Yes, we had regular telephonic meetings since we were all a little spread out to compare notes of where we were at in our investigations, and nobody had located any evidence of the children.
Okay. And this was in November and December of 2019?
November 26th was the contact with Melanie Gibb, and then November 27th of 2019 is when Rexburg continued their investigation at the Pioneer address.
Okay. And so despite the efforts in Arizona to put up a poll cam and to reach out to family members and to reach out to school members, did you have any evidence that J.J. Vallow or Tylee were in Arizona?
None, and that includes speaking with her brother, Colby Ryan.
Okay. And did anything about what Melanie Gibb cause you to call another law enforcement? What Melanie Gibb said to you caused you to call another law enforcement office?
What Melanie Gibb told me?
Yes.
Yes, I communicated with Rexburg Police Department again about what she told me, yes.
Okay. Why did you talk to Rexburg again about after your conversation with Melanie Gibb?
Because it was believed Melanie had custody of JJ.
Okay, and did you have any evidence from Melanie or anyone else that that was true?
No.
Okay, and so then did you communicate back to Rexburg about the possibility that JJ would be back in Idaho?
Yes.
Okay, why?
Because all evidence we had at this point with the Gilbert Police Department and Chandler Police Department is JJ Vallow was not in Arizona.
Okay. Now, did you continue your investigation into the shooting at Brandon Boudreau?
Yes, ma'am.
How did that investigation continue?
We continued, again, we processed the rest of the vehicle for any type of physical evidence, Brandon's specific vehicle. Then, with regard to the Jeep in Idaho, myself, a crime scene technician, and a infotainment specialist, which is somebody who knows how to study computers and vehicles. The three of us flew up to Rexburg, Idaho, where I met with detectives in Rexburg, and we processed the Jeep that was in the police property building. That process included photographs, collection of biological evidence, and collection of GSR evidence. GSR is an acronym for gunshot residue evidence.
Okay, so, and what were the results of the GSR?
The GSR evidence was collected at the rear of the vehicle, near the back window and within the vehicle, and the GSR results tested positive for evidence of a discharge of a firearm.
Okay. The chemicals that could be there were present in the back of that Jeep?
That is correct.
Okay. It's not a definitive ruling, but at least the chemicals were there.
Correct.
All right. Now, I just want to be clear, because then it may be the way I ask the questions. What date was it you did the search for of the Jeep?
The search of the Jeep, I would have to look at my notes.
Okay.
If I may.
Did you have notes and bring them with you today?
I made notes with dates because there was a lot of dates involved in this.
May he be handed his notes after defense counsel looks at them?
Yes.
Thanks.
Am I using the mic okay? I don't want to be too... Thank you, sir.
And the rules are you need to flip it over. So okay, are you done refreshing recollection?
Yes.
Okay, that's all right. We just follow the rules.
I got you.
All right. What date did you go to search the Jeep in Rexburg, Idaho?
The Jeep was searched on November 18th, 2019.
Okay. And so when you and teams went up to Rexburg to search that Jeep on November 18th, at that time, what was law enforcement's interest in Tylee Ryan?
Tylee Ryan was, again, known to be using the Jeep, believed to be using the Jeep, so we were checking to see if she used it, also if Alex used it. But again, we hadn't seen or located her as of that date.
Okay. And in fact, did you ever see and locate her?
No.
Okay. And then after that, I believe you said November 26th was the date law enforcement reached out to Lori Vallow about JJ?
It was November 26th that the welfare check for the children by Rexburg Police Department was made. And then the call I received that night from Melanie relaying information that said otherwise. And then November 27th, which was Thanksgiving, Rexburg then completed a more intensive search of those properties where Alex, Lori, and Melanie Boudreau were living.
Okay. And so after that, What sort of steps did you and the Rexburg Police Department take in this investigation?
Again, primary focus on locating the kids now. I was tasked with writing search warrants for cellular data and location data for the involved parties.
Okay. When you say the involved parties, who are we talking about at this point?
At this point, I'm talking about Alex Cox, Lori Vallow, Tylee Ryan, and Melanie Boudreau.
Okay. Talking about Tylee Ryan, did you receive information about any cell phone data related to Tylee Ryan?
Yes.
What was that data?
The data showed her device was utilized both in Arizona and in areas of Idaho, and at the point of our investigation, it was now showing in the area of the Hawaiian Islands, Kauai.
Okay. And this was in December?
Yes, ma'am.
Okay. Did it ever show up anywhere else?
I believe it was in Missouri for a brief time.
Okay. And that was the cell phone of Tylee Ryan, correct?
That was the cellular device that was associated with her cell phone number and provider, yes.
And subsequent or sort of contemporaneous, because all these things are kind of happening at the same time, right?
Yes, ma'am.
Okay. Did you have information as to the relationship between Brandon Boudreau and Melanie Boudreau in terms of divorce or together?
They were legally married still, but they were nearing the end of their divorce at the time of Brandon's shooting.
Had there been any discussion of life insurance?
Brandon and Melanie had a life insurance policy that required each of them to sign in order to modify or null and void the life insurance policy. At my time in contact with Brandon, that policy was still valid, and if Brandon were to die, Melanie would get $200,000 or more.
And did you have any information about how much Melanie had received as a part of their divorce settlement from Brandon Boudreau?
Relevancy.
Motive, Your Honor.
Relevancy.
Sustained.
Your Honor, may I be heard?
I've made a ruling on that, Ms. Smith.
Okay. Was there, without the amount, was there a payout from Brandon Boudreau to Melanie Boudreau as a part of their divorce proceedings?
Yes, ma'am.
Okay. And did you have any evidence to suggest that cash had exchanged hands between any of these people of interest?
Objection, relevancy.
It's part of a conspiracy, Your Honor.
That I'll overrule.
Thank you. Did you have any evidence that cash had been exchanged between any of these parties involved?
I'm going to object unclear as to who these parties are.
Yeah, that was vague.
Okay, when we say the parties, the people you have identified looking for the cell phones for, Melanie Boudreau, Chad Daybell, Lori Vallow, Tylee Ryan. Did I miss anybody? Alex Cox.
Alex Cox.
Okay. These 5 parties, and as part of your investigation, monetary gain is often a motive for homicide, right?
That is correct.
Okay. So looking at cash amounts and cash's exchange between people or how much money somebody stands to benefit for a homicide is an important factor for an investigator to look at, right?
Yes, ma'am.
Did you receive evidence that any of these 5 people had exchanged money or cash?
Yes.
What information did you have?
There were Venmo exchanges that were made, and there were also substantial amounts of money that were exchanged that were referenced in text messages with each other.
Okay. And while you were looking for Tylee Ryan, did you find any evidence that she'd ever enrolled in college?
No.
Did you find any evidence that Tylee Ryan ever drove that Jeep personally after September of 2019?
No.
One moment, please, Your Honor.
Yes.
Thank you. I appreciate it, officer. That's all, Judge.
All right. Thank you, Ms. Smith. Any cross?
Your Honor, we know that the court has a prior ruling in February regarding the 404B evidence. We believe that all of the information garnered today in testimony was either 404B or so intertwined with 404B that we could not be able to effectively cross-examine him without losing our right to this 404B on appeal. So we're not going to have any questions.
Okay. I understand, Mr. Thomas, then, so there won't be any cross-examination. Then that would conclude the testimony of Officer Ballard. Can he be released from any subpoena?
We would ask that he is.
Any objection?
No, Your Honor.
Okay. That'll conclude your testimony. Thank you for appearing. The bailiffs will assist you out of the courtroom.
Thank you, Judge. Thank you, jury.
We would ask that you strike the last statement where he indicates thanking the jury. I think that's inappropriate.
All right. Let the witness be excused. I'll address that here in a moment. All right. In regards to that last comment, it's maybe something that happens in Arizona, not typical in Idaho, that a witness would address the jury. So to the extent that was any attempt to influence in any way anything besides what was simply testified to, I'll sustain the objection and ask the jurors to please disregard that, even though it was seemed to be a benign comment, but I understand the purpose of the objection. So,
Thank you, Your Honor.
in addition, with that testimony having concluded, I will again provide the jury with an instruction that's been previously provided and will also be provided in your closing instructions in relating to these acts and allegations alleged to have taken place in Arizona. That is evidence that has been introduced for the purpose of showing the defendant has possibly committed acts other than for which she is on trial. Such evidence, if believed, is not to be considered by you to prove the defendant's character in this case, or that the defendant has a disposition to commit crimes. That evidence may be considered by you only for the limited purpose of proving the defendant's motive, opportunity, intent, plan, or absence of mistake or accident. So that's the instruction as it relates to the limiting nature of that evidence that was just entered into by the state. All right. I believe at this point the state intends to not call another witness until tomorrow. Is that correct?
Yes, Judge. The next witness is fairly lengthy, and understanding that we had to end early today for other matters, the state would request that we start that lengthy witness tomorrow morning.
All right. Thank you, counsel. We'll go ahead and have the jurors excused for the day then. We'll take a 15-minute recess or so, then we'll come back on the record for additional argument on an evidentiary matter in this case. So before you leave, let me just give you the daily admonishment. Please continue to abide by that. Don't discuss the case with anyone. Don't discuss it amongst yourselves. Please don't do anything to look the case up, or if you see it in the media, don't follow it at all. Don't do anything that would impair your ability to continue to render your fair and impartial service based only on evidence that's presented here in the courtroom. So we appreciate you adhering to that every day, the court and the parties both. With that in mind, you're excused for the day, and we'll see you tomorrow morning at 8:30.
All right, please.
All right, let me just briefly inquire, counsel, on the argument you want to make. Is that enough time to be prepared for that, 15 or 20 minutes before we take up argument? Yes, sir. Okay, and were you able to provide a courtesy copy of that proposed exhibit to the court?
I was not yet. I'm sorry. I was in witness. I will forward it.
Okay, if you could please email a courtesy copy to my staff, please.
Yes, sir.
Thank you.
Thanks.
Okay, folks, we'll be back in.
Thank you. Please be seated. Okay, we're back on the record on case CR 22-21-1624, State of Idaho versus Lori Noreen Vallow. We've excused the jurors for the day. The court received a proposed exhibit, which would be a demonstrative or summary exhibit being proposed by the state in conjunction with the testimony of an upcoming witness in order to determine the objection outside of the presence of the jurors and without using their time to do this. We scheduled it for this afternoon, and so the court will hear argument on the exhibit today. I've made a quick review of it. I intend to take up argument on it and then make a ruling, most likely just as we get started in the morning, unless I think there's any kind of a ruling that would assist the parties that could be made this afternoon. So Mr. Archibald has raised is going to raise an objection, I'm advised. I'd like first for the state to just indicate that in fact the exhibit intends to be offered and who the witness would be that would offer the exhibit and a description of the exhibit, and then I'll go to Mr. Archibald's objection.
Thank you, Your Honor. It's an exhibit from Douglas Hart. He was the former special agent who ran criminal investigations for several counties in southern Idaho and supervised the agents who do criminal investigations both out of Boise and the Pocatello offices. The agents in the Pocatello office reported to him. He, as the supervisor, had to sign off on every report through every federal officer through the FBI.
Just to clarify, he's an FBI agent?
He is an FBI agent, special agent.
Thank you.
And he retired in 2022 and is now the chief deputy for Canyon County. But he would be testifying as to his role, which has been ongoing in this investigation. And so to be clear, he, every FBI agent, every part of the FBI that had contact with this case reported to him. In addition, and so as a part of that supervisory role, every report, every analysis, every assignment was authorized by him or signed off on by him. And so he has reviewed literally and or signed off on every report done by any member of the FBI in this investigation. But more importantly, but in conjunction with that, he was also an active investigator on this case. Given the resources in the two offices for the FBI and given the resources for the departments, this what the court has heard numerous times, this was a joint investigation because you want me to keep going, Judge?
You may.
Okay. No one officer or department had the resources to track this over the 5 or 6 states by themselves. And so this partnership, he was an integral part of the partnership of these equal agencies. But his role was unique given his experience, his background, and his in-depth research into multiple things. But the state asked him to testify as to the findings he did. It's specifically documented in this exhibit as a summary. It is about the iCloud accounts of Lori Vallow. Those accounts have already been admitted, I think without opposition from the defense. Those records in their business record certification has been referred to by numerous people in terms of specific isolated items. But he will testify as to a summary of those accounts. Mr. Wood, in anticipation of this argument, did a search, just trying to put it together in a PDF. And I think at last count, there were in one of the accounts alone, 23,000 pages of documents that is reflected in the iCloud in one of the accounts that go and are attributable to Lori Vallow. They were handled and returned jointly. There's at over 100,000 points of data or text or records in this. And so the state is certainly not proposing to print them all off and hand them to the jury. And so in anticipation of testimony and in trying to find the cleanest way to present very substantial and important information, former Agent Hart, Chief Deputy Hart, put together a summary, and that summary is based on the original copies which have been available to the defense since 2021 and to per previous counsel before that. He is also included in the summary that he has the line and or area that they could immediately go to locate to determine accuracy. He cut and paste from the original documents into the summary so that there's no conversation about attribution. He also has in order to take a summary and not just regurgitate 100,000 sets of data, I don't think any of us want to spend the year here, he found common topics, common themes that helped him present his findings, that makes it easier to present the information contained in these documents in summary. His background in an investigation, in supervision, in behavioral analysis is outstanding. He has the qualifications to make such a summary. He has the qualifications to take such summary and put it in context of the overall investigation, both from his personal experience and from his training, vacuum, and position at the time. And so the state's exhibit really is a way to move as quickly through important evidence as we can without losing context. It is a fairly lengthy exhibit. However, much of it is because the font is large, and part of that turns to so that it's easier for people to read. So it's easier for jurors to read, the court to read. And so the length shouldn't be determinative, but it's really a summary of voluminous documents in the most cohesive, chronological way the state can, done by the person who did the work.
All right, thank you for the proffer and description of the exhibit and argument as well, Ms. Smith. Mr. Archibald or Mr. Thomas, I believe it's Mr. Archibald that'll argue.
Yes.
Mr. Archibald, what's the contention of the defense in terms of the proposed exhibit? First of all, you've had a chance to review it, correct?
Yes.
All right. And if you'll present any argument in opposition, I'll hear that.
Yes, I'm making a motion, Your Honor, to exclude not only the report, but also the witness, Special Agent Doug Hart. This report was emailed to us May 2nd at 5:49, so 10 minutes before 6 o'clock on Tuesday. And so this is a common practice of the state of Idaho, in this case, from the FBI, to get us all their reports and then hand us a summary the day before the testimony. And so these summaries, again, have been proffered as demonstrative summary of their testimony. So the issue I have with Agent Doug Hart is twofold. One, he has met with many of the witnesses in this case. He has prepped them. He has met with the prosecutor in preparing these witnesses for their testimony. I first heard about Doug Hart's extensive involvement in this case when a witness of the state called our defense team sometime this spring and was concerned that the FBI wanted to talk to this witness again. So I contacted the prosecutor. What are you guys doing? We're not doing anything. The FBI is setting up another witness prep meeting, as it was called. So these witness prep meetings were set up by this agent, Doug Hart, to go over this witness testimony. A dozen or so witnesses, all who have testified here during the last 5 weeks. And so Doug Hart is extensively involved in this case, as the state has just informed the court. So when we found out he was interviewing all of the witnesses, we asked for a recording. So the cops are interviewing all the witnesses. We want the recording. Oh, the FBI doesn't record it, is what we were told. Well, how about a recording from the prosecutors? Nope, we didn't record it. How about a recording from the local cops? Nope, we didn't record it either. So we were, as a defense, in the dark about why they were contacting witnesses again, why they were prepping witnesses again, and not provided with any recording so that we could review them. So maybe this is standard practice for the FBI. Maybe this is what they do. But I don't think we do this in the Idaho courts. I think if anyone was talking to a potential witness, it would be their lead investigator, Detective Hermosillo. Detective Hermosillo has sat here the whole time. He's an authorized agent of the state, but Special Agent Doug Hart is not. He's not a designee of the state, but he's sitting in on all these witness interviews. And so now they want to put him on the stand to testify. So number one, that violates our exclusionary rule. He has done exactly what we don't want witnesses to do, and that is talk to all the other witnesses. Number two, this report that he's generated that we just received contains argument. It contains the state's theory of the case. It's not his investigation of these 100,000 points of data. As the court can now see in this 160-page report, it contains argument on every page. Page 3, these are dates and times told to him. Page 4, common themes. Now, common themes, that's an argument. That's not a summary. Lori and Chad's doctrine on page 6. That's an argument. That's not a summary. Page 7 through 10. Doctrine. That's an argument. That's not a summary. Pages 10 through 18. Obstacles to remove. That's an argument. That's not a summary. Justification for their conduct. Pages 18 through 57. That is an argument. That is not a summary. Manipulate. Pages 57 through 79. That is an argument. As we just heard a witness today say, oh, that was manipulation. Oh, isn't that convenient that the FBI agent who he met with a day or so ago has that in his report, the FBI agent, pages 79 plus. Manipulation is what FBI agent Doug Hart has on every page in his, not every page, but from page 79 on. He refers to manipulation, and that's argument. That is not a summary. Removing obstacles, that's an argument. That's not a summary. So what we have here essentially is the FBI saying, from all of our investigation, here, state of Idaho prosecutors, here is your closing argument. Here is how you sell this to the jury. Here is our evidence, here is our argument. And we're going to disguise this as a summary so that the jury can read it. And it's not appropriate. The FBI is not in charge of this case. The federal prosecutors are not in charge of this case. This is a state case run by the state of Idaho prosecutors. And so this is the FBI's way of telling the locals that this is how you do a case. So this 160-page summary, so-called, it's just cherry picking. All of this data has not been admitted. There's not 100,000 pages that's been admitted. If it has been admitted, Your Honor, then they don't need to be summarized. So if this evidence has already been admitted, we don't need a summary. We don't need this witness. So I'm very concerned about this witness testifying, again, because he's talked to, I don't know how many, because I haven't been told that information, so I can only guess. But the lay witnesses he's talked to, all the FBI agents, the state of Idaho has just now said Doug Hart was in charge, so all the FBI agents who have testified have reported to Doug Hart. So he's now summarizing the case, and that's just inappropriate. So we'd ask that he be excluded, and then if the court's not willing to exclude him entirely, exclude his summary. Thank you.
All right. Any rebuttal argument, Ms. Smith?
Yes, especially since some additional issues were raised, Your Honor.
Yes.
To start with,
would you address first the timing of the defense receipt of the 160-page PowerPoint?
I think a lot of that had to do with
Are you confirming it was received 2 days ago?
The exhibit was sent on May 2nd. And part of it was that's when we got it for him. He has another job. It's an exhibit to ease and create his testimony. It has been on the exhibit list for a substantial period of time.
It's one thing to put it on a list, but nobody's been able to see it until 2 days ago, correct?
Understood.
Okay.
And understood. But no, the timing on that is correct. I think there's another piece of it is when he submitted it to us, there were some things on there that we weren't sure had come in. I didn't want anything in there about Joe Ryan. And so part of that was if we're going to use an exhibit that is summary, we also have to make sure when we proffer it to the court or to opposing counsel, there isn't something that the court's previously excluded. Sure. And so there's a degree to which with summary exhibits to be offered to a jury, we have to walk a very fine line that we don't violate any of the court's previous rulings. And that's part of the reason he's towards the end of the case, because you certainly wouldn't offer a summary exhibit that has things in it you either A, can't get in, B, don't get in, or later are told don't go there. But absolutely, that's what it was. The second piece is, I do find it interesting, had the state done preparation of its witnesses with just a prosecutor present, I guarantee you, and the court's already heard it, defense counsel would be in here saying disqualify those prosecutors because they talk to people alone. So at this point, the defense can't have their cake and eat it too. They got to pick. Discovery is ongoing. We had the officer or the agent who was involved in the interviews sit in on our conversations with our witnesses to make sure if the witness said something new, if they gave something different, that the person who had talked to them or worked with them could report that, turn it over to defense as quickly as it could, even if the discovery deadline had passed, because we recognized that deadline was for admissibility, did not mitigate our responsibility to disclosure. And so to say the person with the deepest knowledge should not be in the room to make sure that Brady or exculpatory information is a stretch. Prosecutors absolutely would commit malpractice if they put their witnesses on the stand without talking to them, preparing them, and making sure they followed the court's rules. We did that in this case. We're not going to put somebody up there we don't know what they have to say. And we made sure we had a witness present to ensure the commitment we made to you, which was discovery was ongoing, was committed. So it is a bit rich for the defense to say, hey, You've given us too much discovery, and the person who gives us the discovery we want to exclude now because they did their job. So on the discovery issue, that is our obligation. He did what he was told. If the court wants, they can certainly question him about a cross-examination. The other piece is no one has discussed testimony with him that occurred in this courtroom, and he will tell you that. And so what he did in anticipation of testimony is different than what came out in, if it is different than what came into the courtroom, he can't speak to that. He is not going to comment on what somebody else said or did unless we have to lay a foundation for prior inconsistent statement or it's otherwise admissible. What his testimony will be about in this case is about the work he did on the iClouds and how it fits into the overall investigation. That was his job. He did this work. The other piece is these items were admitted under State's Exhibit, and forgive me, it just went out of my head. It's the iCloud summary. I want to say it's 104, but let me pull it up. The Apple Certified Business Records for Lori for Style, the Apple Certified Business Records for Lolly Time. It was Exhibit 29. It came in probably day 3 of the case. Multiple witnesses have referred to those documents. The original and the entire content, all 100,000 data sets plus the individual pages, which total over 24,000 pages of documents, have been available to the defense. We certainly could throw them on a disk and give them to the juror, but that would be really burdensome. So what former Special Agent Hart did was to be able to accurately convey his testimony, was create an exhibit to aid himself in explaining his findings to the jury and to aid the jury in understanding the evidence they've been giving them. That's part and parcel of a summary exhibit under Idaho Rule 1006. The other piece of it is to just throw things up there without context does not make sense. Those are common themes and ideas he found. The fact that it could also be used in closing argument just shows the validity of the evidence and the investigative conclusion. Investigators follow leads. They follow the evidence where it gives them. That evidence gives them themes and ideas, and they present that to the state. This document is a direct example of what law enforcement does, and it summarizes in a usable way for this jury voluminous records that he has personal knowledge and information related to that. It is a way to take what is a vast amount of information and give it to this jury and to the court in a manageable setting. The discovery in this case is extensive for all the parties, and the court's seen that. We cannot ask this jury to sift through 100,000 records without some frame of reference, without some theme, and expect them to come up with a good result. And this solution is the best solution that the agent and the state could come up with.
All right. I've heard argument on the motion. I'm prepared to make a ruling at this time, having considered the argument. I will note I did briefly scroll through the proposed exhibit, and one thing I'm not entirely sure we got on the record is whether or not it's been previously marked or labeled with a number, so we can correspond in the record what I'm referring to and what you've been referring to. Is it a state's proposed exhibit number?
I apologize. It should be States 183. It's on the physical copies. I apologize. It's probably not put on there electronically. I simply forwarded it to counsel in the court without an exhibit sticker just to try to get it to people.
Okay. All right. So the proposed exhibit 183, I'll start off first with the defense contention that Agent Hart should be excluded for violation of the court's exclusionary order. That order is narrow in scope to what the rule prohibits, which is a witness listening to trial testimony. And while the agent may have interacted with other witnesses, I don't see any indication that the conduct would go directly to the court's exclusionary order unless he states on the stand that he's been talking to witnesses about their testimony or reviewing their testimony before he has testified in the case since trial started. Because he's not the state's designated agent that gets to sit through testimony. So I'm not, at this point, don't see any violation of the court's exclusionary order. That's something that the witness can address on the stand once he's placed under oath and potentially in cross-examination if the defense believes he may have violated the order. So at this point, the record doesn't make clear that there has been any violation if he were discussing the case with witnesses before they testified. So the witness is not excluded. The next question then becomes, if Agent Hart testifies, does he get to use what's been proposed as Exhibit 183? That's a summary, or it's labeled or been argued to be a summary under Idaho Rule of Evidence 1006. That rule does allow a proponent to use a summary chart or calculation to prove the content of voluminous writings, recordings, or photographs that cannot be conveniently examined in court. The second part is the person offering it needs to make it available for examination before of the underlying information that goes into making the summary. I think the state's established that this information, while very voluminous, has previously been provided in discovery. I think there's been enough of a foundation laid that part 2 of the rule would be complied with where it was prior disclosed in discovery, and potentially the excerpts that are included in this proposed exhibit have been available to the defense. I am going to exclude that exhibit, though, for the following reasons. Number one, the size of it, the contents, the volume of the exhibit itself is concerning to me that it was provided to the defense late in the trial 2 days ago. It's a 160-page exhibit. Not fair to have the defense need to be able to go back through what everybody concedes is a huge amount of information and determine whether or not the 160-page exhibit comports with the underlying information that was used to make the PowerPoint. The bigger issue I see also is I do agree with the defense that it's not just a summary of content. It's not here's an email, here's a text message, here's what it says. That's all allowable under Rule 1006. What the exhibit does is, when I look at it, it does. It looks like a closing argument PowerPoint we're going to have at the end of a trial where someone's tying all the evidence together, they're editorializing on the evidence and what it means, they're interpreting the evidence, they're pulling it together in such a way with some of those terms that Mr. Archibald indicated and that I saw in there as well, talking about what are the common themes. It refers many times to what it calls the affair that was taking place. I think it goes right into the provenance of the jurors to interpret the evidence and for them to make determinations about what the evidence means. The amount of what I think is argumentative type of language that is used to tie it all together, to me it does strike me as like a opening first closing argument that would be played for the jurors before the prosecutor then makes a closing argument. So if it were an exhibit of admissible evidence that was being proposed in a closing, I wouldn't take any issue with it, but the way it's been prepared and presented, I think, goes outside of the scope of what the rule intends. The rule simply allows for summaries of the information, but not comment on the information, not interpretation of the information, not statements of argument that claim to tie the information to the theories of the state in the case. So it's an improper use of Rule 1006. So the exhibit as it is would not be admissible. With that in mind, I would indicate to the state, if the state submitted a follow-up exhibit, and I understand already with the timeliness issue, I still may or may not allow it, but if all of that argumentative language was removed and it was simply references for convenience of certain communications you think he should testify about, that is something that the court would consider admitting. So the proposed 183 will not be admitted, and I'll sustain the objection on those grounds. If the state wants to have the witness create something else, and I feel like there's adequate time for the defense to be able to review it, assuming it wouldn't come in at 160 pages again and is something they could meaningfully prepare for, knowing the information contained in there has already been disclosed since May 2nd, I may consider allowing a different exhibit that assists the witness, but this one will not be allowed. So that'll be the ruling on that.
In anticipation of that, may I ask a couple questions should we will be trying to do that, and I really want to try to avoid successive sort of suppressions, if I may. So the objections are to the common themes discussion that's in there and to the headers. And is there an objection, just so I'm clear, to the timeline that he puts in there, which is critical to his, when he discusses why a particular text is referenced? So I'm sorry.
I don't think timelines are objectionable as long as they're not, labeled about what they mean relating to some theory of the case. Also, these are, there was a lot of information in that PowerPoint that was argumentative. So I think the state can sort that out with my comments on what I think is proper or not. I will further entertain any objection based on the timeliness, again, depending on what comes back. If it's a cut-down version that looks manageable, and I think the defense has had an adequate opportunity to review since they have received the underlying information and discovery previously, it may be admissible, but at this point that's about as clear as I can make it for the state.
Understand. And so should the state request to not call him tomorrow, but instead to call him on Monday? Understanding we follow the court's rule, is that something the court would entertain?
Well, your order of witnesses is up to you, but I'm not intending to just take a day off to let you have your witness prepare an exhibit tomorrow. We're going to be starting trial again in the morning, so if you've got other witnesses that can fill time tomorrow, it's up to you to choose the order of witnesses. All right, Mr. Archibald, do you have any questions or comments on the court's ruling? Okay. Thanks, counsel. That'll conclude the issue for this afternoon.